pray that item number 43, 44, 45, and 46 may be taken as upgraded item, my lord. It will take much a bit time, my lord, less time. Because, my lord, in similar case, your lordship was pleased to issue notice. And only notice is to be issued.
That's the 15,000.
Yes, madam. In one case, notice has been issued, my lord, and in those cases also notice may be issued.
Okay. Heard Mr. M.A. the learned counsel appearing on behalf of the petitioner. Issue notice, making it returnable on. Yes. When did I fix the other matter? You have the early order?
List accordingly, it is 6 weeks, madam. Returnable by 6 weeks. Order was
Show me that order.
21/4/2023.
It is same order back. Same order. 42 to 43 to 46. Same order.
Much obliged.
I want to contact to your lordship item number 27, sir.
Hmm?
This was item number 27, sir. May I please, this may be updated
20?
7.
Okay. Apply to it.
May I please, Lordship, I recommend item number 11 of today's lordship. Lordship, in this case, we want to withdraw the petition, lordship. Because Liberty to file it.
Why liberty? Liberty is the
No,
problem.
actually, what happened, lordship, during the filing of the case, we were not able to get the address of a necessary party, who is the first wife of the father of the petitioner, lordship. Now we are able to get her address, Your Honor. So, lordship, we want to make her a party.
Withdraw means you want the address of whom?
First wife of the father of the petitioner. It's a pensionary matter. There, allegedly, there are 2 wives.
Your name?
Miss B. Sharma.
Ms. D. Sharma, learned
Sharma.
counsel appearing on behalf of the petitioner, submits that in view of the fact that the first wife of the father of the petitioner was not made a party, she wants to withdraw the instant petition with the liberty to reply. Taking into account the state submission, the petition stands dismissed on withdrawal. However, liberty is given to the petitioner to reply by adding the necessary part.
Much obliged. Lordship, I will update item number 35.
Why?
The suspension matters are last update it was left over now. 35.
Oh, that matter.
Yes, lordship.
Where Rishikesh Sharma was appearing. Is that the matter? No.
Yes, lordship.
Where the, oh no, not that matter. It's there in the list. Check it out. What you are asking for? The matter is there.
35, I think.
Is there or not?
Yes, lordship.
Then don't mention it. Next. 28.
Yes.
What do you want?
For that, the matter will come up after
Your name?
SD lawyer.
Hmm?
SD lawyer.
You are paying for whom?
I am appearing on behalf of Mr. H. Omaya.
A. Somua.
Yes.
At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Hello. May I please, Lordship? Lordship, I beg to mention the matter item number 5 for adjournment. Lordship, Mr. Yarpuya is on land. He is on leave and leave note is also been given.
Hmm?
Leave note is also been given with the consent of the standing council, PNRT, Lordship.
What is this matter about?
The matter is pertaining to pension related matter.
Understood. That is why this matter has come before this court. What is this matter?
Lordship, in that matter, I mean, The petitioners are praying for there should be given pensions under old pension scheme.
Oh, that matter. We'll take it up. Next. Next.
That is for listing lordship. Is it listing? That for listing lordship. It is suspension method for admission lordship.
Suspension. Okay. We'll have it on 12th of June.
Date. What short date lordship?
Today is what? 19th. Okay. 5th of June.
Item number 1, promotion.
My lord. My lord, in this case, I am making all the response. My lord, the DP has already initiated against the petitioner, and the DP report has been submitted to the disciplinary authority, and quantum of punishment will issue by the disciplinary authority, granting opportunity to the petition.
You are asking for setting aside of what?
My lord, the suspension order, my lord. In the meantime, after filing of the my lord, petition, my lord, departmental proceeding has been started, my lord. So I have no grievance, my lord, at present, my lord. Okay, my prayer is that, my lord, disciplinary proceeding may be concluded within a time period.
Disciplinary proceedings is over.
Over, my lord, but
An order has been not passed.
So you are going to take steps for issuing notice. Have you issued notice to him?
no,
Pursuant
my
to the
lord,
inquiry.
it will take 15 days, but because
So you are going to take steps. I
steps.
dispose it
Often
off, saying that nothing remains. He is
Just now
only
he
challenging
informed me
the
that it
suspension
will
order.
just now he
Now the inquiry report has already been given,
Right.
and you are going to take steps for giving him the show cause,
Oh.
second show cause notice. Are you giving or not?
not my lord.
Why?
Just
that he again comes-
DP report has been submitted to the disciplinary authority.
Yes.
Disciplinary authority for pass any order issued to the and to be issued to the petitioner, granting opportunity.
That is what I am asking you. Are you going to give it or not? You have to
Not
give it.
now. Just now we have received the report.
So you may take a decision
Yes,
as regards whether to go ahead with the punishment. If you want to go ahead with the punishment, obviously you will ask him to show cause on the basis of the report.
yes, my lord.
Otherwise, you may drop and proceed, isn't it?
Yes, my lord.
So you-
15 days is necessary.
So 15 days time, or I give you 30 days time, you initiate that process.
Yes, my lord.
Dispose it of. Heard, Mr.
He go away, my lord.
D. Gogoi, the learned counsel appears on behalf of the petitioner. Mr. A.K. Datta, the learned counsel appears on behalf of the respondent number
All, my lord.
1, 2, 3, and
1 to 3, my lord.
1, 2, and 3.
Hmm.
The instant writ petition is taken up for disposal at the motion stage. The petitioner herein is agreed by the order dated 30/9/2022. Where is that?
My lord, page number 18, my lord.
Page number
18.
18. 30/9/2022. Whereby the petitioner was placed under suspension. It appears on records that pursuant to the filing of the instant writ petition, the respondents have already filed their affidavit in opposition on 4th of April 2023. In the said affidavit in opposition, it has been mentioned. Have you mentioned it? That it is over. Inquiry is over.
No, yet now I got information, my lord. Today.
Had filed the affidavit in opposition, resisting the claim of the petitioner. Be that as it may, Mr. A.K. Dutta, the learned counsel appearing on behalf of the respondent, submit that a departmental inquiry which was initiated against the petitioner have already in the departmental inquiry so initiated against the petitioner, the inquiry report have already been submitted by the inquiry officer, and the department, respondent department, is in the process of taking appropriate steps in regard. The learned counsel for the respondent further submitted that in terms with Article 311(2), if any action is taken in pursuance to the departmental, in pursuance to the inquiry report, opportunity would be granted to the petition, which may take a month's time from today. Taking into account the same, taking into account that the inquiry report have already been submitted, and the department, respondent department, is in the process of taking steps in pursuance to that inquiry report. This court does not find any ground to interfere with the order of transfer challenged in the instant proceedings. Accordingly, the instant petition stands dismissed, however, subject to the observations made herein.
Number 2.
My lord, kindly have a look, my lord, earlier order, your lordship was pleased to pass, my lord, on 23rd 1, 2023, my lord.
Yes, you filed your additional affidavit.
My lord, one additional affidavit I filed, my lord.
How many did you want to file?
Yes, my lord. Page 29, my lord, running page 29 onward.
Yes, Mr. Barbuya, tell me who is the department, which department officer has been assuring you that the payment would be made?
My lord, education, my lord, elementary, right?
Who?
But district level authority,
Who?
district elementary, the block.
So for the last 13 years, 10 years, there has been assurance being given.
Because my lord, they are, my lord, still working, my lord, the department.
Then
But they are not paying. One, my lord, similar order, my lord, passed
by
by this now report, my lord.
regarding,
Same, my lord, from their group, my lord, page 26, my lord.
show me. Where?
Page 26, my lord, then, my lord, the relevant portion, my lord, page 27. Here, my lord, after filing this petition, my lord, director, my lord, decided by its own, my lord, to release their salary, my lord, and quoting this decision, my lord,
So there is, the authorities have given a particular finding that yes, we are still bound.
yes, my lord.
But where is that for you? Yeah.
My lord, so my lord, similar my lord, they also consider
Why?
because my lord, we both are my lord working under him.
So what?
This is my lord page lordship kindly have a look page 28.
I've seen page 28.
28 my
It
lord.
does not inspire the confusion.
But, this is also a decision from my lord 13/6/2011 to 28/2/2017.
What is your name?
My lord, our name my lord Jagnesh,
Okay. Heard Mr. A.M. Borguia, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Katonier appears on behalf of the Secretary Education Department. Mr. R. Barbujari appears on behalf of the Finance Department. Issue notice making it returnable by 26th of June 2023. As the respondents are duly represented, extra copies of the petition be served upon them by the petitioner by 22nd of May. The case of the petitioner herein is that the petitioner is entitled to the area salary for the period from 1/6/2011 to 28/8/2013. The respondent, it is the further case of the petitioner that the petitioner have approached the authorities time and again. However, the same have not been paid. Be that as it may, on 3/1/2022, the District Elementary Education Officer Kachar has also requested the Director of Elementary Education for sanctioning an amount of rupees 2,47,684 as the area salary of the petitioner. Petitioner and another for the period from 1/6/2011 to 28/8/2013. The Learned Counsel appearing on behalf of the Secondary Education Department is directed to obtain instruction as to why the said amount of area salary have not yet been paid to the petitioner.
3,
Keep them.
Yes, Mr. Bhatti.
Yes, मतलब इतना मतलब taking मतलब return back the excess amount
Hmm?
excess amount मतलब already मतलब refunded मतलब so treasury चलन है because मतलब due to that reason pension has not been processed मतलब subsequently मतलब I have receiving pension monthly pension मतलब regularly. Except मतलब the petitioner overstayed in service 4 months.
2,39,589. So that is the amount. You have paid that.
Paid. This notice may be issued, madam.
Why did you ask for time for 4 weeks on the last occasion?
Occasion, my lord, that if honorable court made a query, my lord, whether my lord the date of death is known by the petitioner or not,
Date of?
part, my lord, and date of retirement.
Where is it?
My lord, kindly see page 15, the service book, my lord. Date of birth reflected 1/6/1961. Accordingly, my lord, he is also declared on my lord, June
Oh,
2021.
yes. Then
My lord, thereafter, my lord,
when did you retire?
retired, my lord, on 3/11, kindly see, my lord, page my lord, 33, my lord, issued a letter, PO issued a letter, my lord, stating that, my lord, 3/11, vernacular, my lord, S35.
So you worked till 30/10/2021.
My lord.
Then
But then, my lord, my contention is that, my lord, the service book is the custodian of the block education, my lord. And no retirement notice has been served, my lord, prior to my retirement.
then what do you say about Rule 95?
My-
What do you say? Retirement notice given or no notice given, how does it make any sense? You knew it. It was mentioned out there in the service book that is the date of birth. Then why did you continue beyond?
On that aspect, my lord, no retirement notice has served, my lord, petitioner.
Let's see Rule 95.
I am continuing the
See Rule 95.
my lord.
Then can you get any benefit?
I am served, my lord.
You served. Who has asked you to serve? You should have not served beyond that. Have you pointed out that I was supposed to retire? Have you informed the authorities? Why? I think you should get 50% back. 50% should be taken from that official, na? Who was supposed to make him retire.
Well, otherwise, he was aware of the date of birth. Man.
Absolutely. Because there is already a notification of office memorandum also to that effect, 1992.
In the service book, also, there is a requirement, my lord.
Huh?
Page 17. In the service book, there is a requirement, my lord. Page 17, my lord. The entries in this page should be renewed and reattested at least every 5 years. And the signature in line 8 and 9 should be dated. So, my lord, every 5 years, my lord, that has to be renewed, my lord.
No, understood. But in all other cases where I have done it, I have touched on this.
Yes, sir.
Starting from Nilufer Islam to on that day, Sir Mr. Roy. The date of birth was either not written or was written but
Wrongly.
wrongly.
Entered.
But this is a case where the date of birth was mentioned.
Yes, my lord.
Then tell me.
Only contention, my lord,
But
no,
you knew it.
due to, my lord, not
I would have understood if you had
notice.
not known it. How did you get this copy of this service book, the photocopy?
My lord, after my lord, forwarding the pension proposal, my lord, I
Hmm. So you didn't know your date of birth. You were working as in what capacity?
a teacher of the LP school.
Teacher. Then you must be having an admit card.
But at least that is not, my lord. So, most probably, my lord,
Are you telling me you didn't pass your matriculation?
all passed, my lord.
Then when were you appointed? Your appointment was when?
9 June 1987.
87. Then also there was a requirement of having matriculation.
My lord.
Then you must be having an admit card. Admit card, there must have been a date. Then
I have not disputed on that date of birth.
Then-
only, my lord, I have not due to, my lord, I am overstayed due to not issuing the retirement notice prior to my retirement.
then what do you say about this thing? About Rule 95? Tell me. What can be done? When did you return the money?
Malat kindly see malat treasury chalan page malat 37. 23/12/2021.
Hmm?
23/12/2021. Yes, 30
And you retired when?
retired malat as per malat service book malat I authorized retirement 36 June malat 2021. But third malat till malat October 2021. 4 months malat excess. Overstay.
And who was the blocker? Who was your head officer?
Blocker
But
name-
there is no fault on his part. Yes, there is a fault only to the effect that he should have issued the notice, for which I think you should be entitled to 50%, and 50% should be deducted from him. Huh? What do you say? No, then only these people will learn. Your department is otherwise very happy. Now putting you up, because he's entitled to 50% of his salary, at least for what work you have done. Isn't it?
In fact, he was aware of the date of birth.
Understood. So let
He ought
him,
to have informed the
but
authority.
isn't he entitled to 50% of his salary for what work he has done? I'm not saying that the state would lose. The remaining 50% should be deducted from your officer. What do you say, Mr. Borpujari? You're the finance. If there is no accountability on the part of the person to issue the superannuation notice, they are going scot-free. Something has to be done. So 50% he should get and 50% you should, because the state otherwise can't have unjust enrichment of more than that.
So page 33 of the petition, here it transpires that the petitioner has been informed that his date of birth, his date of retirement was 36/2021, page 33.
Yes, no, I've seen that.
Yeah, and his date of retirement is 30th of June 2021, and this communication was issued on November 2021, just few months.
And now he is trying to recover.
Yeah,
And the petitioner has accordingly paid the money.
yeah, he has deposited.
Now, after depositing the money, what is the responsibility of that officer? There's nothing. Can these people go scot-free? You do one thing. I'm issuing notice. I'm also going to be giving you the direction to inform this court on the next date who is that officer concerned. We will make him, maybe he's there or may not. We'll also make him a party as to why against him that amount should not be recovered. 50%. If this is done, then in one case, if it is done, then only something will happen.
Because by dint of this memorandum which are applicable in the field, the authorities are duty bound to
Absolutely.
at least 1 year ahead.
1 year
1
ahead,
year
they
ahead.
should be knowing it.
But at the same time, petitioner has also
Heard
been
Mr. K.R. Padgiri, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Katonia appears on behalf of the respondent number
1, 4, then 6 and 7.
1, 4, 6, and 7. 6 and 7. Mr. R. Pujari appears for the respondent number 3
and 8, madam.
and 8, and Mr. S.R. Bolwa appears for the respondent number
2
5. 2
and 5.
2 and 5. Issue notice making it returnable on 28/6/2023. As the respondents are duly represented, extra copies of the petition be served upon them by 22nd of May 2023. The case of the petitioner herein is that the petitioner is aggrieved by the recovery of an amount of rupees 2,39,589 on account of overstay. From a perusal of the documents, more particularly the service book enclosed as Annexure 1, it clearly reveals that the date of birth was duly recorded in the service book as 1/6/1961. The fact that the petitioner did not know the date of birth cannot be accepted in view of the fact that the petitioner was a teacher and his date of birth was duly recorded on the basis of his admit card in the matriculation examination. In terms of the service book, the petitioner was supposed to retire on 30/6/2021. However, the petitioner overstayed till 31/10/2021. It is the specific case of the petitioner that the petitioner continued to render his service as the respondent authorities, more particularly the block development of who's the person who should have issued the superannuation notice?
Vinod Morang.
Huh?
33, my lord, page 33.
Block elementary education officer.
PO, my lord.
As the block elementary education officer who was the head of the establishment did not issue notice of superannuation as is required under Rule 95 of the Assam Service Pension Rules, 1969. Let this matter on the returnable date, the learned counsel appearing on behalf of the respondent, Elementary Education Department, shall apprise this court as to why there was no notice issued to the petitioner, and further to that as to whether the petitioner is entitled to the refund of the amount as claimed. Instruction shall also be obtained by the learned counsel appearing on behalf of the petitioner, on behalf of the respondent, as to who was the person concerned, who was the concerned official who was required to issue the notice of superannuation to the petitioner. And the present posting so that he can be added as a party to the instant proceedings.
Another 4.
My lord, regarding wife, my lord, there is no dispute. I took time from your lordship to examine. But regarding child, my lord, a daughter, unmarried daughter is there, my lord. So, my lord, daughter is entitled to pension, my lord, share of pension, because she may be illegitimate female.
She is entitled to what?
Pension, my lord, share of pension. As a daughter, she is entitled to pension, my lord. And your lordship would be pleased to see page 27. Why will not get, my lord? Because Mary is voida initio. Voida initio. So, my lord, page 27, my lord. Admit card. Here, her father's name is shown. Paresh Chandra Chaudhary, who is government employee.
So what is your prayer here?
My prayer, my lord, apportionment of pension.
Oh, how can I give it?
No, my lord, now apportionment of pension means, my lord, pension is given to first wife. But my lord, as daughter, my lord, as per pension rule, daughter is entitled now. Daughter is entitled, my lord. My
Which
lord,
daughter is entitled?
my lord.
Which daughter is entitled?
Daughter is entitled. Now question remains, my lord.
Whether she is a daughter?
My lord,
Can you say her to be the daughter?
my lord, illegitimate daughter.
Is
That
it mentioned
point-
out there? Illegitimate daughter will also come in.
My lord, yes, my lord, there is some decision
That's
of
it.
this court also that illegitimate daughter.
So,
son
Mr.
is
Sheikh,
entitled.
kindly get those decisions
My lord.
and then satisfy me. Then I will issue notice. How much time more?
My lord, after 2 weeks, my lord.
Huh?
After 2 weeks. After 2 weeks.
At the request of Mr. M.A. Sheikh, let the matter be listed.
Apply, sir.
Five.
Yes. What is your case?
Lordship, the matter pertains to the pension-related matters of tax collectors. The petitioners are the tax collector, and they were being appointed on ad hoc basis in the year 1996, but subsequently their service was extended time to time, and in the year 2003, their service were eventually regularized. But after superannuation in the year
Show me your appointment order. What is this appointment, Mr. Devnath? NXR 1? What type of appointments are these? For 90 days and all?
Is a temporarily, it is in the second line, it was temporarily appointed.
Understood. A temporary appointment also, if you go by these rules, there might be a temporary appointment also, a permanent or a temporary appointment. A person may be a temporary, then also he may be entitled to. It may be a temporary post also, arising out of a pensionable establishment. That is the requirement. Now tell me, what type of these appointments are there? These are being done by the Director of Panchayat and Rural Development. These are being done just at a random in a pick and choose manner.
This manner I'll need to get instructions of.
Huh?
But if it was done in this manner, I'll need to get instructions. But their services were regularized only in 2013.
2013,
13.
that is, I've seen page 42.
Yes, ma'am.
So are these ad hoc employees or what is this ad hoc employee business?
Okay, kindly give me some time. I'll get the
Hmm?
instructions as far as all this.
Heard, Mr.
N.A. Mazharbuia.
N.
A. Mazharbuia.
A. Mazharbuia, the learned counsel appearing on behalf of the petitioner, Mr. N.K. Devnath,
For all the response.
appears on behalf of all the respondents. Issue notice, making it returnable on 23rd of June 2023. Steps be taken by way of registered and as the respondents are duly represented, the petitioner is directed to serve extra copies of the petition by 22nd of May 2023. The case of the petitioners, you have paid the court fee? How many petitioners?
Two petitioners, Lordship.
Paid the 100 rupees? Good. It's done. The case of the petitioners herein is that the petitioner were initially appointed temporarily as tax collectors. They continued to render services and as their services were extended from time to time. On 1st of June 2013, the petitioners' services were regularized along with others under the Panchayat and Rural Development Department with the designation of tax collector. Tax collector,
Yes, Lordship.
everybody,
Oh, yes, Lordship.
tax collector. Mr. Counsel, without making finance, you have a big problem. Where's the finance? Yes. Because here he is asking for this old pension, new pension.
Finance is a necessary party.
Finance is a necessary party. It is the further case of the petitioner that the petitioner therefore are entitled to the pension in terms with the pension, in terms with the rules of, in terms with the Assam Service Pension Rules 1969. And they are not covered by the National New Defined Contributory Pension Scheme 2009. ওপৰত লিখিব দেই অকণ ওপৰতে appears for respondent number 1, 2 and 3 বুলি ক'লো নহয় এনকে দিব upon perusal of the petition and taking into account the claims so made, this court deems it proper that without the finance department of the government of Assam being made a party to the instant proceedings, no effective writ can be issued. Considering the above, this court therefore impledes the Commissioner and Secretary to the Government of Assam Finance Department, having his office at Dispur, Guwahati 781006 as the respondent number 4. Mr. Arbor Pujari, the learned standing counsel for the finance, being present in the court, duly accepts notice on behalf of the respondent number 4. As the respondents are duly, the registry shall make necessary correction of the records by incorporating the name of the respondent number 4, newly. As the respondents are duly represented, extra copies of the petition be served upon the learned counsels by 22nd. The respondents we will have this on 18th of July. Issue notice making it returnable on 17th of July. 17th of July. 19th of July. The respondents are directed to file their affidavits by 17th of July. The registry shall also show the name of the Standing Counsel Finance in the courts.
I have that.
Another 6.
Yes.
May I please, Your Lordship?
Why this matter was adjourned?
Earlier, Your Lordship has sent me sometimes to solve the case was matter, but there.
Why?
Your
What are you challenging?
Here I have challenged
Suspension
the
order.
suspensions and the departmental proceeding, my lord. But there is a development, my lord.
Why you are challenging the departmental proceeding?
The departmental proceeding is challenged because the departmental proceeding is initiated by an authority which is not my appointing authority, my lord. That is the only ground. But there is a development, Your Lordship. Yesterday, I have received an information from my client that the department has revoked his suspension order.
Revoked.
Revoked, my lord. But the order is not yet in my hand, Your Lordship. So may I pay Your Lordship, please, then Monday or
Okay, we'll have it on Monday or Wednesday.
Wednesday, my lord. In the
Yeah.
meantime, I will place the.
At the request of the learning council to the petitioner, matter stands adjourned till 24th of May.
Seven.
It's a matter of termination.
Yes, why did you seek for an adjournment on the last occasion?
It was not for adjournment, your lordship. It was submission was made, your lordship, but the question arose whether.
Oh, that one, I remember.
Yes.
What did you find out? Whether the writ is maintainable?
Yes, I have got two orders of the court of the High Court, your lordship.
What are they?
Where Justice Michael Jonas has admitted the case of a Northeast Small Finance Bank. An employee was terminated. Your lordship.
Huh?
An employee of the Northeast Small Finance Bank was terminated in a similar case, and the repetition.
But did they arrive was anything mentioned out there?
Yes. Lordship.
Was the issue of maintainability taken?
Yes, lordship. Here issue notice returnable within 4 weeks. Petitioner.
Oh, that is not
learned
there.
counsel for the petitioner submits that the petitioner has been dismissed from the service, and
You have to satisfy me.
lordship.
I'll give you again time.
No, lordship. I have also a case law of a recent judgment was passed by the Kushal Kishore versus State of UP and others, your lordship.
Where?
In WPC Criminal number 113 of the 2016 Supreme Court, where it was stated right Article 19 and 21 rights can be enforced against the private individuals and entities.
Huh?
Right. Article 19 and 21 rights can be enforced against private individual and entities. The recent judgment is for 3 years.
That's the Constitution bench judgment.
Yes, so it votes for 4:1 majority.
That was the matter whether the minister can make any statement.
It was there were 5 questions arose, your lordship. Whether the same can be taken, repetition can be maintained in the private bank also, the private entity also. And it was said to the affirmative.
Where is it?
Lordship, I have some. It was a judgment of 300 copies, 300 pages, your lordship. I could bring the 300 pages. I have some of the pages here.
Chalo, we'll issue notice, but keeping the maintainability of the repetition open.
I will bring some more case laws to lordship. In the meantime, they will also cite their.
Heard Mr. S. Ahmed, the learned counsel, appearing on behalf of the petitioner. Issue notice making it returnable on 19th of July 2023. Steps upon the respondent number 1, 2, and 3 be taken. Why the state of Meghalaya is a party?
State of Meghalaya party because he was terminated based on the fact that the criminal case is pending against him in the state of Meghalaya.
Are you asking for any relief against that criminal case?
No, lordship, the matter is the thing that is happened, the case that is pending in the court of Meghalaya is beyond our control.
Investigation into
It's a
powers
FOCSO
invested in the respondent and what are you asking for? For recall of the termination order. That is okay.
Yes.
For issuance of just and appropriate direction for just and proper direction for investigation into the powers vested with the respondents and exercise of the same within the purview. What is this? For issuance of an appropriate redirection area not to harass the petitioner unnecessarily. Who is not harassing? Who is harassing you?
Lordship, the matter is that this person's service has been terminated, your lord. On the basis of the fact that the case is pending in the court of Meghalaya, that the FOCSO matter has been pending upon him, and the case is pending more than a year, and now this is beyond the control of the petitioner. And if the reason is that the case is pending in the Meghalaya and the criminal case pending for that, his termination has been served upon him. So we have made a party to the magistrate of Meghalaya, lordship, because if they have to finish the case within a year, it is beyond our control, lordship. If they have done a mistake, if they have.
Mr. Counsel, how many years of practice?
7 years.
Very good. If it is a Meghalaya, something has to be done. Why are you not approaching the Meghalaya High Court?
So the termination letter has.
How can you do everything in this matter? You have made also the Reserve Bank of India a party. Why?
Because they are regulated by the rules and regulation by the Reserve Bank of
So?
India.
So what? How does it matter that Reserve Bank has done or not? You have been terminated. Your basic thing is you couldn't have been terminated, taking into account that unless there is a plea, there is a guilty, there's somebody, there's a finding of guilty, you cannot be terminated. That's all. So under such circumstances, why are you dragging the Reserve Bank of India unnecessarily? You have any problem with the investigation being done out there in state of Meghalaya? Go to Meghalaya. There's a Meghalaya High Court out there. How can this court exercise that jurisdiction? Tell me. How can this court pass an order to the Meghalaya police to investigate in that manner? This court can't do all these things. That is why, otherwise, why there is no only one High Court everywhere? One High Court can be there for everybody, one Supreme Court or one High Court. Every state has been given their individual jurisdiction. How can you draw the state of Meghalaya out there?
The termination letter was issued by the Beltola office. So
Understood. You are challenging that order on this basis of whether a writ is maintainable or not, that we'll look into it at a later stage. But how are you bringing the state of Meghalaya or the Reserve Bank out here? Reserve Bank has no business. Are you asking for a relief that the Reserve Bank should lay down guidelines to that effect? No. Why are you making unnecessary the Reserve Bank a party? And the state of Meghalaya. You have any problem, go to Meghalaya.
notice may be issued to only the responsible. Notice may be.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. At the outset, the learned counsel for the petitioner submits that as the petitioner's grievance is limited to the challenge of the termination letter dated 21/12/2022 issued by the respondent number 1. The respondent number 2 and 3. The names of the respondent number 2 and 3 be struck off. Accordingly, the names of the respondent number 2 and 3 are struck off. The registry shall make necessary change in the reports. Issue notice making it returnable on 19th of July 2023. The case of the petitioner herein is that the petitioner was terminated by the impugned order of termination dated 21/12/2022 without holding any disciplinary inquiry, as well as also on non-existent grounds, which was contrary to the order of appointment of the petitioner. The respondent, number 1, shall apprise this court on the next day as regards the respondent are directed to file the affidavit insofar as the claim made by the petitioner. The issue pertaining to maintainability as well as the entertainability of the instant petition is kept open. Yes.
Forward case, the husband of the petitioner for more than 20 years of service, but he is after during period he received the terminal casualty,
Covered case with what?
Sanjita Roy, forward case,
6 years.
6 years, he will calculate then 24 years,
Where? Now you have not been granted the pension because of that. You dispose it off and make the necessary verification to that effect and look into it. Heard Mr. K. R. Padgi, the learned counsel, appearing on behalf of the petitioner. Mr. R. Dhar appears on behalf of the respondent numbers 1, 3, 5, and 6. Mr. Rahul Dhar appears for so-and-so and Rupak Dhar appears for the respondent number 4. Mr. You are not there.
Financial of treasury is 7.
R7.
Oh, 7 is there. Mr. R. Putari appears for the respondent number 7. And Mr. You are there. 8 Alugda appears for the respondent number 2. The case of the petitioner herein is that the petitioner
Husband of the
was appointed as a master rule worker in the office of the assistant executive engineer. The instant writ petition is taken up for disposal at the motion stage. The case of the petitioner herein is that the petitioner,
husband of the petitioner,
or the husband of the petitioner, was initially appointed as a master role worker under the office of the Assistant Executive Engineer, Sipazar Rural Road Subdivision PWD in the district of Dorong, Assam. The petitioner, husband of the petitioner, joined on 12/7/1992. In the year on 22/7/2005, on 13/9/2005, the services of the petitioner was regularized with effect from 22/7/2005. Thereupon, the husband of the petitioner retired from service upon attaining the age of superannuation on 31/1/2017. It is the case of the petitioner that the total service period of the petitioner was 24 years, 6 months, 19 days. And the total period of service of the husband of the petitioner was 24 years, 6 months, 19 days. However, on the basis of a office memorandum dated 25/2009, 6 years was deducted. And on account of the petitioner not having 20 years of qualifying service, the husband of the petitioner was only given terminal gratuity. The learning counsel for the petitioner submitted that on the basis of which the 6 years have been deducted, the office memorandum on the basis of which the 6 years have been deducted have already been held to be illegal and arbitrary. By the coordinate bench of this court in the case of Sanjita Roy and others versus State of Assam, reported in 2019 to GLT 805. It is therefore the case of the petitioner that if the 6 years is not deducted, the petitioner would be entitled to the areas of the pension of the petitioner as well as also the family pension. Mr. Borpujari and Mr. Dhar tell me, he was regularized with effect from 22/7/2005. He retired on 30/10/2017. 17.
17.
The moment he is regularized, doesn't he have the qualifying service, irrespective of anything? Why you are going into this 20 years? And first and foremost, I don't get that 20 years is only when a person is not confirmed. But when a person is confirmed, where is the concept of 20 years? And now you know, with that new judgment of the Supreme Court recent of Justice M.R. Shah, and I'm now incorporating that if that period is, qualifying period is not there, and he has been regularized, then so much of the period of the past service should be taken for the purpose of meeting the qualifying period. Because otherwise, the Supreme Court said that it would be otherwise unreasonable that after working for such a long time, and thereupon at the fag end of their service, they are regularized and then not to be entitled to.
Once regularized, my lord, a person comes within the definite cadre.
So he's otherwise also entitled. Why we are going into the Sanjita Roy business and all these things?
My lord, the follow-up of my lord, page 35 of the report, original 2009 OM was there.
No, I understand everything. But show me the document or any rule which requires 20 years of service, except that office memorandum.
Yes.
And that is why that office memorandum has been said, this 2009 office memorandum came in, so look here, the 6 years further will deduct.
Yes.
That means you have to have 26 years to get the benefit of this. And it is there in that circumstances, this court said that you have already said 20 years. Now, how can you make it 26 by this office memorandum? But when he is being regularized on 22/5/2000, 22/7/2005, then he's otherwise entitled to. It seems there seems to be not, this aspect doesn't seem to be clear from everybody's perspective. Otherwise, why do we keep on getting these type of matters every day?
Yes, my lord, PCC will have to take a call, my lord, to a new case for it.
Fresh way.
Huh?
Case for it. PCC department,
Action.
External Public Defense Department, will have to take a call. And because now the law have developed within the recent time.
And you got Sanjita Roy.
And
No. Sanjita Roy is okay, but that will only apply to that office memorandum. But how can you apply here when he has been regularized?
what would be the benchmark, my lord, for MR workers and my lord, if a person is regular at one point of time, he enters the definite cadre. So he inevitably becomes entitled to pension.
met.
Met.
So he has qualifying service.
For that reason, my
108B, he gets the benefit.
perhaps my lord, clarificatory poem or notification is required to be.
Required.
As per the my lord, cause
That will simplify
I've heard the learned counsels for the petition parties. From a perusal of Annexure 1 to the writ petition, it is apparent that the husband of the petitioner the services of the husband of the petitioner along with various other employees were regularized with effect from (22/7/2005). A further perusal of Annexure 2 is the communication issued by the Executive Engineer PWD, whereby the husband of the petitioner was issued the superannuation notice intimating him that he would retire on 31/1/2017. Accordingly, as the husband of the petitioner was regularized in service from 22/7/2005, and he rendered service till 31/1/2017. The husband of the petitioner, in view of Rule 31 of the Assam Service Pension Rules 1969, read with Rule 108B of the said rules, would be entitled to pension the judgment of the courted bench in the case of Sanjita Roy Supra would be applicable in respect to those cases coming within the ambit of the office memorandum dated 6/9/2003. Under such circumstances, the action of the respondent authorities in not granting the pension to the husband of the petitioner, and now the family pension to the petitioner, to which she would be entitled to in terms with Rule 140 Tell me one thing.
That 20 years. That aspect of 20 years, my lord, that has been dealt with in Sanjita Roy. If Lordship may be pleased to come to.
Understood. Yes, what does he say?
Page 41 of the report is a part of, my lord, there is a office memorandum. However, while office memorandum dated 6/9/2003, the government has introduced requirement of 20 years of.
That is what I'm saying. That is for not confirmed persons.
Yes.
Now another problem arises, however. Whether he will be entitled to pension if we take that, taking into account that he was brought into service on 22/7/2005.
Yes, then again, my lord, OPS and PS issue will keep in.
It will be a big issue.
No,
But you have accepted it and given him the terminal benefit.
Yes.
You have a lot of problem with this.
Because this 2009 my lord communication at page 35 It doesn't explicitly spells of, my lord, speaks about that earlier 2003 OM,
2000 page?
page 35.
Ah.
Page 35, my lord, is the communication whereby, my lord, deduction of 6 years have been, my lord, called in. This is 2009. 6 years has to be deducted. This was put to challenge.
Right.
This was put to challenge in Sanjita Rai. Now, in Sanjita Rai, how the court has dealt with the matter, that, my lord, will find at page 41.
Oh, you see here. No. Here you get the point. And you come to page 35.
Yes, my lord.
Downline.
Yes.
The penultimate line. The Assam Service Pension Rules 1969, Assam Financial Rules, Assam PWD Code stands amended to the extent of the order contained herein. Formal amendments will follow. Meaning thereby, you have extended this.
Yes.
The Assam Pension Rule.
Yes. That has been extended to, my lord, MR workers. And this aspect of the matter has been dealt with by this court, my lord, in Sanjita Rai. There at paragraph 12.
Understood, but where do you bring in this 20 years?
So 20 years has fallen from that 2003 earlier.
But that 2003 is those who are not confirmed.
Not confirmed.
But if those people who are confirmed, then how do you take note
Yes,
of?
that aspect of the matter is perhaps, my lord, silent. I'll have to check.
No, if you see that office memorandum 2003.
Yes, 2003 OM is perhaps not annexed here.
No, yes, Mr. Patel, can you give it to him?
162, my lord, it is test
Huh?
type, my lord. In pension code, my lord, it is test type. It is regarding-
I know that. Just give it to him. Just give it to him. This office memorandum categorically says that those who had not confirmed.
Yes.
And this comes from 1996.
Yes.
So this will only therefore you don't find the 20 years anywhere.
Anyway.
20 years you find it here and in rule 139.
Yes.
No, 134.
Yes. The difficulty is because
34 is as regards the earlier pension scheme, not this
Yes.
as per the 69 new,
Yes.
not this 69. The prior to that till 1954 there was another one. No?
Yes.
So that.
But yes, the difficulty has arisen because this 2003 notification OM as well as this subsequent letter dated 2009, they don't speak about regularization. But
No, 2009 it says.
No, 2009 it is.
It says, consequent to the government's decision to regularize the services of master roll workers of different departments.
Yes.
This is prior to, after the petitioner's thing has happened.
Yes.
Government has been considering for the past time the question of counting of a portion of master roll period of service towards pension and gratuity.
Yes.
So this is on the basis of a decision which was taken to regularize.
To regularize. But that the genesis of this aspect of the matter, that if we go to at least 2003, this 2003, my lord, doesn't appears to speak of any regularization. It only says confirmation in service. So that
No,
means
there is no
the
confirmation is required.
No, but 2003 says so. My lord, I'm reading it. In continuation of this department OM number so and so dated 12/9/96, it is reiterated that the state OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead or is not the moot point. Any confusion in this regard is against the spirit of the OM referred to above. It is therefore clarified that pensionary benefit as contemplated in the above OM shall be admissible to a government servant who died after rendering 20 years of continuous service. So the My lord, condition precedent here was 20 years of continuous service. Now, subsequently in 2009, that issue of regularization has been brought in here. Because 2003 doesn't speak of any regularization. It only speaks of plain and simple 20 years of continuous service.
The question, as you could see from the Supreme Court judgment, the regularization is not a concept of recruitment.
Absolutely.
So regularization is an idea by which the government takes an action to give appointments or whatever.
It is
The moment you
entry to the
confirm
cadre. Yes.
a person who is working temporarily or doing something, you are confirming them into the service, bringing them within the service. It is a facet of a regularization.
It may be a facet, but then, my lord,
It
regularization.
is something in the words of the Supreme Court in Indra Swani, it says reservation is a larger concept. The facets are relaxation, giving posts, seniority, all these things are facets.
Nomenclatures may be defined at different levels, my lord, but the lordship will kindly appreciate by dint of regularization, a person enters into a definite cadre. When a person is regularized, he enters into a cadre.
No. By dint of regularization, the person does not enter into the cadre. Because of the fact that the government decides to regularize them, the person is being given an appointment so that he enters into the cadre.
That's what, my lord.
No, there's a difference.
No.
Otherwise, if you say that regularization brings him to the cadre, would have a far-reaching consequences.
My lord, my submission is, if a person is regularized, the immediate natural corollary will be, the consequence will be that he has to be regularized against the post, and that post has to be a part of a cadre.
A person may, therefore, it is absolutely a policy decision, regularization.
That's what.
Regularization is a
correct.
policy decision,
Absolutely
but
correct.
the effect of the regularization is the appointment.
Yes, that's what. So here,
Here, although the departments keeps on using the word we regularize their services,
nomenclature is
but
differs.
actually you can't regularize the service just on the basis of regularization. The moment you say that regularize their service means you are bringing them within the cadre.
Definitely,
So
regularization.
how do you bring somebody in the cadre? Can by way of a government say that I regularize and bring somebody into the cadre if the cadre does not, the rules does not permit so?
Yes.
Then wouldn't that government's decision be contrary to the statutory rules?
Absolutely.
So that
therefore,
is why you can't have the concept of regularization to mean that it is a source of anything. So upon the idea of regularization or the policy decision to regularize, these appointments are being made. They don't use the word regularization, but these are appointments, fresh appointments.
yes, appointment. So therefore, there has to be a harmony with the policy decision vis-a-vis the rules. Yes.
Because otherwise it will,
Yes,
because there cannot be a policy decision because the rule, because these are statutory rules.
In fact, that is not within the scheme of the constitution also.
Yeah.
Yes. But here, my lord, will kindly strike the difference. The difference is that, my lord, in 2003, this OM doesn't speak of regularization. It says only confirmation. The focus is the length of service.
No. You see, 2003, this OM only came because of the 96.
96, yes.
You have to understand it.
Yes.
2003 is a reiteration of what is there in 1996.
Yes.
Because there seemed to be some confusion.
Yes.
So in 1996, the same word without confirmation was.
Yes.
Because at that point of time, the question of regularization was not in the minds of the state.
Yes. Yes.
The regularization only came after these OBB cases and all these cases which came in. Then the concept of regularization is being brought into, that we are now regularizing them or doing something to them.
Sometimes just before 2005.
Yes. So these are all regularizations happened then.
Yes, absolutely correct. Yes.
Prior to that, it was only the concept of confirmation. Therefore, if you see the 1981 Act also, it doesn't say about regularization, it says about confirmation.
Yes. Stipend rate is a confirmation. What is confirmation?
All these things, the confirmation word is being used.
Right.
That is why this word is there, because it is not here which is come for the first time. Therefore, it comes from 1996.
Yes.
There, The same word, without being confirmed.
Yes, without being confirmed. Anyhow, my lord, here the length of service will assume importance here.
So he's already having,
So
so he
that's
gets it.
so 2003, my lord, clearly in no uncertain terms, it has provided for 20 years. 2009, my lord, this subsequent.
But how does he
communication
come
is-
within this?
Yeah. No, this 6 years reduction.
No, how does he come within this office memorandum of 2003? Because he's already confirmed.
He's already confirmed.
The moment he's already confirmed,
Yes.
then what remains? He's already in the cadre.
He's already indicated, but for the purpose of calculation of pension.
That is 10 years.
So that is 10 years, but his pension will date back from the date of his appointment, the calculation of pension, because the quantum may vary. That is why, my lord, this length is taken into account. Because if his pension is to be calculated, this is the total length of his service. He enters into the service at one point of time and he superannuates or he dies, or whatever it is. There is a cessation of employer-employee relationship. In between, there is a date of regularization. Now, if pension is to be calculated from this date of regularization, then, my lord, perhaps the earlier portion will have to be given a go by. That is
No, that has to be, because why, therefore, the Supreme Court in the recent judgment of Nasa,
yes.
the name was Uday Pratap Singh, Uday Pratap Thakur or something.
Yes.
You have got the Supreme Court version or the SEC online? If you see the Supreme Court version, it is paragraph 6.3, 6.4, and 7. The specific question involved therein was that can you take the earlier period of service or date back from the date of their initial appointment? Supreme Court said, no, you can't do that. The moment you do that, there will be a violation insofar as those persons who have been regularly appointed and touch upon 14 and 16. Therefore, the Supreme Court says that you only take into account so much of the service is required for making it the qualifying service for giving it. Something on the minimum of the scale.
Yes, my lord. It is law is changing, my lord.
So this is how you give
Yes,
it.
yes, yes.
So therefore, on that basis, there was one case where I was finding that it was 18 years. That day I delivered the judgment. He was there. 18 years. Now this 18 years you can't bring in 67.
Yes.
1 year only.
1 year.
So I can't bring that.
Yes.
But he was again regularized with these lot. Same lot. So, and he retired on in the year 2007.
Madam.
So it is just 2 years. But he was from 89.
Yes.
So I say that it will be only that portion of the service will be taken so that he only meets the qualifying to get it.
Yes. So ultimately, pension is a fallout of the statutory duty. Statutory duty again is a fallout of the rules. So it has to come within the four corners. Lordship is correct.
So this is how it has been done.
Yes.
So let's see what happens. Yes, last.
My lord.
As well as also the family pension to the petitioner. Would be contrary to the rules of 1969. However, as this court is disposing of this matter at the motion stage, this court finds it relevant to give the authority concerned an opportunity to make necessary verification as regards the order of regularization, the order of superannuation of the husband of the petitioner. Accordingly, therefore, this court disposes of the instant writ petition with a direction to whom? Commissioner.
I think assistant executive engineer.
No, we have to give the direction to many people here.
Yes.
Commissioner, direction to the
Executive engineer.
respondent number 2. Director of pension has no role. Accountant general will be there. 1,
6 will be
no,
there.
no, these 1, 3, so many direction to the respondent number 3 will do. Or 1.
But he had worked under the establishment of R6. R6 is having the custody of all service. Service
Okay,
particular.
directing the respondents in the PWD department
Yes, yes.
as well as the office of the accountant general AE to make necessary verification as regards the authenticity of the appointment or the order of regularization of the petitioner, husband of the petitioner, as well as the notice of superannuation so issued to the petitioner, husband of the petitioner, and as to whether the petitioner, husband of the petitioner, and upon such verification, it is found that the petitioner, husband of the petitioner, had the qualifying service in terms with Rule 108B of the rules of 1969. The petitioner be paid the arrear pension, some other benefits are there? No.
Other benefits, DCRG,
You are along with other pensionary benefits to which the husband of the petitioner would have been entitled to, as well as also the arrear family pension and the regular family pension to the petitioner.
Yes.
Footstop. In doing so, the respondent authority shall also deduct the amount paid to the petitioner as terminal gratuity. The said exercise be completed within a period of 4 months from the date a certified copy of this order is served upon the respondent number 1 and 4. 4 is accountant general, na? 1 and 4, respectively.
Item 9.
My lord.
I retired as the headmaster of Sevaguri FPS School on 31/7/20. My lord, my date of joining was 19/7/1991 at Puri every. My lord, may kindly come to page 15 of the petition.
Yes, what is this case about?
My lord, this case is about the fact that it has been 9 months since my pension has not been paid. My lord, what has happened?
Why the pension will be released to you?
My lord, what has happened with the case is that by the letter they had asked me to submit.
Kindly come to page 12 of your petition. Read. That he is entitled on his retirement from service with effect from 31/7/2023.
Well, 22 it is. It is a, my lord, the representation. My lord, the
In the prayer,
prayer. My lord, sorry, it is a typo error. 31/7/2020. My service book is also appended in the set.
then
My lord, it is a typo error.
Why you have not been given the pension?
My lord, what has happened in the case is that I was asked to submit my HSLC original certificate to the authority. If my lord comes to page 16 of the writ petition.
Hmm.
My
Yes.
lord, I had accordingly submitted my HSLC original certificate.
Hmm.
But my lord, the fact there is one fact in this case. My lord, there is a discrepancy in my age regarding which has been wrongly recorded in my HSLC certificate. My lord, what has happened is that it has been wrongly recorded, and I had intimated the authorities beforehand. If my lord comes to page 18 of the writ petition, I had given a representation to the district elementary education officer Gulaghat, wherein I had told them that there is a discrepancy in my age and that my age as recorded in my admit card is correct. I had given an affidavit to that effect as well, declaring my correct age. The affidavit is in page, my lord, 24 of the writ petition, my lord. If I may read it out, my lord. Page 24, my lord, comes to pointer 3, my lord. That in the original HSLC certificate issued by the Board of Secondary Education Assam, my age on 1st of March 1979 has been wrongly recorded as 18 years 8 months in place of 16 years 8 months. And my lord, this affidavit I had submitted to the authorities concerned way back in 2020. If my lord would kindly come back.
So what was mentioned in your service book?
My service book says 31/7/22, my lord.
Your service book says 1762.
Date of birth. My lord, my actual date of birth is 1 May 1960.
1 May,
1960.
but your date of birth has been recorded as 1/7/1962.
My lord, wrongly recorded. That is because of the discrepancy, the HSLC certificate and the admit card. I had intimated the authorities way back in 2020. If my lord would kindly come to page 18 again.
But tell me.
Page 18, my lord. If my lord would kindly peruse this page, my lord, I have already submitted here that I have already intimated the block elementary education officer way back in 27/9/2020 regarding the same, that there is a discrepancy in my age and that my age on my admit card is the correct age. I have appended my admit card as well, my lord. The subsequent pages.
So what should it be your date of birth?
1st of May 1962.
1st of May 1962.
Yes.
But it has been written as 1/7/1962. It is wrong.
Wrong.
So it should be 1/5/1962.
My lord.
Then
My lord, if my lord would kindly come to paragraph my lord, in 13 of the writ petition, my lord, that is on page 10. My lord, what has happened is that I was called by the authorities and I was told verbally that this is the situation we are having where there is some discrepancy. My lord, we had told them and way back in 2020 only we had informed them that this is the problem and this needs to be sorted out. My lord, now if I may refer to.
When did you inform?
My lord, in 27/9/2020 by an affidavit to the block elementary education office, Gulaghat. My representation.
That you are going to retire when?
That I am going to retire soon, and that.
When?
My lord, date I have not given. I have said that, my lord, my date was approaching. Like my date of retirement was approaching. It was round the corner. So I told them that.
So as per you, when should you retire?
My lord, I should retire on May 2020 instead of 31/7.
May or 30th of April.
My lord, 30th of
April 2020.
Right.
Now, when did you retire?
I retired on 31/7/2020.
Why did this period go extended?
My lord, this period based on accepting because I was only given, if my lord comes to page, my lord, page 26 of the writ petition.
So you say that you should have retired on 34/90/2022.
Right.
Taking your date of birth should have been 1/5/1962. But the authorities did not do anything. They allowed you to work till 31/7/2022.
Right.
And accordingly, now they are asking for that period.
Yes.
Isn't it your
Yes,
case?
fine. But officially, they haven't given me any notice or anything that I have overstayed or anything like that. Just verbally, they have told me that this is a discrepancy in your case. And since then, I have not been entitled. My lord, I have children also who are studying currently. Very hard for me. If my lord would kindly come to page 26 of the writ petition 1. This is a letter from the Gulaghat South Block, South Education Block, Purupothar. My lord, they have categorically stated that you will complete your.
Yes, your name?
My lord, PR term.
Heard Mr. P.R. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. B. Talukdar appears on behalf of the respondent number 1, 2, 4, 5.
5 my lord SSA.
Huh?
5 SSA my lord. Mission coordinator.
4,
6.
6.
What a name. I'm referring to SSA name and number.
Mr. S. Bora appears on behalf of the respondent number 5. Mr. Rupak Dhar appears on behalf of the respondent number 3. Issue notice making it returnable on 21st of July 2023. As the respondent number 1 to 6 are duly represented, extra copies of the writ petition disturbed upon them by 22nd of May 2023. Insofar as the respondent number 7, steps be taken by way of registered as well as usual. You want an early disposal?
My lord.
Petitioner is further directed to take steps upon the respondent number 7 by way of the stay routed through the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner herein is that the petitioner, in terms with his admit card of the matriculation certificate of the, in terms with his admit card, issued by the Board of Secondary Education, ought to have retired. Or in the case of the petitioner is that the petitioner's date of birth in terms with the admit card issued by the Board of Secondary Education was 1st of May 1962. However, on the basis of the high school leaving certificate, the petitioner's date of birth was inserted in the service book as 1/7/1962. This aspect of the matter, the petitioner, it is the case. It is the further case of the petitioner that this aspect of the matter was brought to the attention of the home.
My lord, it was brought to the attention of the block elementary education officer, Gulaghat.
To the block elementary education officer Gulaghat by submitting an affidavit in the year on
27/9/2020.
27/9/2020. However, the block elementary education officer did not take any steps and allowed the petitioner to continue in his service till 31/7/2022. Pursuant to the retirement of the petitioner, the Director of Pension, who has raised that issue? Who has raised the issue?
My lord,
that you have extra overstayed?
my lord, it was verbally informed to us.
Who?
My lord, my lord, uh, I don't know what.
Pursuant to the retirement of the petitioner have been taking steps before the authorities concerned for the release of the pension, but however, the pension have not been released. On inquiry, the petitioner have been informed by the respondent authority that on account of overstay, the pension of the petitioner have not yet been released. The respondent are direct in the elementary education department as well as how does Sarva Shiksha come into Samagra Shiksha? The respondents in the elementary education department
Non-liability certificate is provided.
are directed to obtain instruction as regards the claim made by the petitioner and apprise the court on the next occasion.
My friend provide me two sets of copy, my lord. My friend provide me two sets of copy, my lord. It was not provided.
And I have issued notice. Now he's bound to. Why two? You were not issued a copy.
No, I will now funny. My name is also not shown in the call.
The registry shall also indicate the name of Mr. S. Gora appearing on behalf of the respondent number 5.
Yes, yes, yes.
Yes, sir. May I be given the liberty to make the correction of the prayer regarding that date 31? My lord.
Item 10.
This is regarding suspension allowance, my lord. Petitioner was placed under suspension by order package 27/5/15, my lord. That is kindly see page 13.
You have not got your suspension allowance.
Not given yet.
Suspension means subsistence allowance you have not got.
No.
Why?
Proposal was made, my lord. Kindly see page 23, my lord.
Then
Then nothing happened. My lord, PO, my lord, forwarded to the my lord director, my lord.
heard Mr. H.R. Ahmed, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatoni appears on behalf of the respondent number 1, 3, 4, 5. Mr. Arbor Pujari appears for respondent number 2, and Mr. Rupok Dhar appears on behalf of the respondent number 6. Issue notice making it returnable on 26th of June 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 22nd of May 2023. The case of the petitioner herein is that the petitioner is entitled to an amount of rupees 2,79,797 on account of area pay and allowances with effect from 1/6/2015 to 29/2/2016 and suspension allowance. It is the case of the petitioner that though the district elementary education officer had submitted the proposal to the director of elementary education way back on 9th of October 2019, but no steps have been taken from the office of the director of elementary education or even by the secretary to the government of SAV, Department of School Education. The learning counsel appearing on behalf of the respondent, elementary education department, as well as the school education departments, shall apprise this court on the next date as to why the petitioner have not been paid the amount so claimed.
Obliged.
Well, same matter.
Same matter, my lord, lordship on 9. Lordship had already seen two cases on 17. Lordship had picked on 9/6. my lord.
Petition এটা সিদিনা লৈছিল যোৱাকালি Wednesday.
I'm anything order of this.
Got that order, same order. এইটো সেই মেটাৰটোৰ লগত একেদিনা লিষ্ট কৰে।
Absolutely.
Notice yes.
13.
13 is covered by a lordship judgment. Lordship matter relates to the right to transport under the 2020 Act. Lordship. One is entitled to file an application and they have to consider it. Lordship has disposed of such a similar such case. Lordship, earlier I was in this petition, but since your lordship asked me, it will be restricted to one petitioner only. So I, for the rest of them, has withdrawn. They filed again.
Oh, that matter.
No,
Only one matter.
My
The
lord,
matter is pending with the BTC.
PTC.
Where's that order?
That has been annexed. Lordship. Page 38.
I disposed it of, na?
Your lordship.
We'll consider it, my lord. Now I am bombarded with all that documents, my lord.
Very good. You only said, remember? What happened? Have you considered the
No,
application?
no, now this is not been considered, my lord. This is another new petition, my lord. Two petition. There are many notifications that equal numbers of persons who had been to be transferred from this state to the PTC. There are many conditions have to follow it.
Now, what is this minute?
Manoj? Just now I have been bombarded with this. Because the number of person going from the state to BTC must be equal.
So you have to take a decision
Decision, man, we'll consider that if it is.
because this court didn't give a decision to the effect.
Lordship only, lordship,
I only say taking into account the limited grievance of the petitioner and upon taking into consideration the submission of Mr. Asbora, the learned counsel for it, and disposed of with a direction to the
Paragraph number
Secretary Education Department, BTC, to consider the
Consider.
application of the AR and pass appropriate orders for
If it is-
issuance of AR for transfer if deemed fit.
man, this order.
The said exercise be done within a period of 1 month.
Lordship, lordship.
Itu same order এটা কৰি দিব হা এই নামকেইটা সব একে প্যারাগ্রাফ 2 নালাগে আৰু how many petitioner one
Now it is single. Earlier it was 60. Lordship,
now it is only one আৰু এটো 2 and 3 নালাগে 2 3 4 নালাগে হা প্যারাগ্রাফ 2 3 4
Only the school name will change.
5 পৰা দি দিব
Only the school name will change.
স্কুল নেমটো চাই ল'ব হা আগতে কোনোবা এখন স্কুলৰ পৰা এখন আছিল এইখনত কি হ'ব আৰু অনলাইন নম্বৰটো যোনটো কৰিছে সেইটো অনলাইন নম্বৰ will be different হা on so and so date will be different full name হয়তো underline make up the
Number will be at page 35.
2 3 and 4 প্যারাগ্রাফ নালাগে ঠিক আছে
Same order in 14.
14 also.
same order তাতো হেৰি why do I have to look into
No,
this?
I will take. I'm taking back.
Ready.
Only
Please, your lord.
Yes, what are you challenging?
Page 38, my lord, the order of suspension.
38
38, my,
Panchayat and rural.
yes, my,
Who has done it? Deputy Commissioner.
yeah, deputy commissioner, first one. Only on the ground of being detained 48 hours in judicial custody. And subsequent when the charge sheet has been laid, wherein my lord, I have given clean sheet, my lord, Charge sheet has been laid by the police investigating officer in this particular case. The PS case number 62 of 2022, when I have given clean sheet. my
Now,
lord.
have they issued the memorandum of charge to you?
No, not at all. Last 1 year, they have not issued a memorandum of any my lord memo of charges. So you can come to page my lord 39.
30
Page 39, my lord.
draft charges in respect of
Well, last para, my lord, that it clearly says that remaining charge against the petitioner does not arise as he was not involved in knowledge of it. Last para, my lord. It is by a report called by the respondent number 5 from the respondent number 4. According to respondent number 5 by this communication, submitted report 5. That's why the subject of the case is
no, understood, but who is the deputy commissioner to do this? Why you have been, is he the appointing authority?
No, my
Huh?
no,
Yes? Mr. Debnath?
no, my lord, he is not the appointing authority.
Then how did you put him to suspension? Is he empowered to do that? Yes, madam. You are there for the deputy commissioner. Are you the appointing authority? Don't tell me you want the instruction.
Lordship, page number 20, Lordship. The petitioner is temporarily appointed Lordship. He is not he is casual employee Lordship.
Page 22.
Page number 20.
Hmm.
The engagement is purely temporary.
Hmm.
His appointment is temporarily appointed.
Hmm. Then this is no whatever may be.
Page 22.
But who are you? And what is this page 22?
22, my lord.
In
it is-
pursuance to the order dated demand following casual employees of so and so are allowed to draw fixed wages. No, this is only minimum of the scale of work. This has nothing to do. You are still temporary. But how did the deputy commissioner exercise that power?
Lordship, I have to see instruction for that Lordship.
Get your instructions. If they want to do it, let them do it, the panchayat.
I also filed one restrictive appeal under Rule 30A. That has not been considered. Page
To
40,
whom?
To Deputy Commissioner. As he suspended, as he made suspension order, my
No, appeal is filed again to the same authority who puts somebody to suspension.
yes, my
How is it possible? It can't be. The appeal will always be to a higher authority.
having received the said appeal, my lord, rightly or wrongly, my lord, then he, my lord, asked for a report from the respondent number 4. Kindly come to page, my lord,
Now we'll issue a short notice.
page
You-
43. once-
No, Mr. Khan. Let me issue a short notice asking whether the deputy commissioner has the jurisdiction. As he's not your employee, then how are you putting under suspension? Mr. Debnath, is it possible?
Not supposed to happen like that.
Huh?
Not supposed to happen in this manner.
Ah,
But then I'll also need to get
tomorrow these people will do whatever may be. Heard Mr.
FKR. FKR.
And so the Learned Council, FKR Emmett, the Learned Council for the petitioner. Mr. N.K. Debnath appears on behalf of the respondent number 1,
4 and 5.
4 and 5. Why are you making the finance a party? What does finance have to do with the
For
suspension?
last 1 year, my lord, they have not paid a single money during suspension period. Well, they have not,
You are asking for subsistence allowance also.
yes, not,
Who is supposed to pay the subsistence allowance to you? Order, where is the question of Assam discipline and appeal rules being applied? Isn't it, Mr.? How do you apply discipline and appeal rules to ad hoc employees? Huh? The suspension expert, Mr. Ardhar.
My lord, please 38.
As a temporary employee, you are applying the discipline, not discipline. Yes, draft charges and all.
Yes, but if you go by the suspension order, it doesn't say so that, but my lord.
No,
Yes,
here you see down below.
Down below,
During the period of
6
suspension,
to-
they will be entitled to subsistence allowance. So you thereby you have incorporated 53.
No, they have been Even my lord, suspension order was done under 6.2. It
Yes.
says
How?
that is what my lord. That is what my lord. Even I am confused, my lord. If the ad hoc, my lord. 6.2 under 6.2 it was done. He was arrested. That's why.
And he files an appeal to the same authority who suspends. It's heard Mr. So the learning counsel for the petitioner, Mr. N.K. Devnath appears on behalf of the respondent number 1, 4, and 5. Mr. Dhar, you are appearing?
My lord, I will appear, my lord.
Because this is necessary.
My lord, I will
Mr.
appear.
Rahul Dhar appears for the respondent number 3. Mr. Arbor Pujari appears for the respondent number 2. Issue notice making it returnable. This is a short notice. How does the deputy commissioner get the authority? Where we are today on 19th, we'll have it on 26th. 26th May. Get just the instruction to that effect. How did he do it?
My lord.
Issue notice making it returnable on 26th of May 2023. Steps be taken upon as the respondents are duly represented. Extra copies of the writ petition be served upon them during the course of the day. Serve it today. The petitioner herein is aggrieved by the order of suspension dated 6/7/2022, issued by the Deputy Commissioner Hailakandi. That is the respondent number 3. As well as which other order? Upon perusal of the materials on record, it transpires that the petitioner is an employee under the Department of Panchayat and Rural Development. Department. This court had put a specific query upon the learned counsel appearing on behalf of the respondent number 3 as to whether the deputy commissioner is the appointing authority, appointing oblique the disciplinary authority insofar as the petitioner is concerned, thereby empowered to issue the order of suspension. Further to that, it also appears that the petitioner herein is a casual employee. Under such circumstances, this court further put a query upon the learned counsel appearing for the respondent number 3 as well as the respondent number 1, 4, and 5 as to whether the Assam Service Bracket Discipline and Appeal Rules 1964 shall apply, and further to whether FR 53 would be applicable insofar as the case of the petition. List according. 16
Admittedly casual employee.
is there.
He has also received my lord minimum basic pay. He has
Yes,
also
it is
received
there.
minimum basic pay.
Since DCS overstep his jurisdiction, my lord.
What to do? Your office.
My lord, only one prayer, my lord. That the name of active finance is shown in the conflict.
I to deliver. Look, huh? Yes, Mr. Ali.
My lord, this is a matter, my lord, relates to suspension of employee, my lord. He was a principal of college, my lord. He was arrested and subsequently released on bail, my lord. He filed an application for reinstate him. It was not done, my lord. Suspension order, my lord, page 21.
6th of January 2023.
Lord.
When did you got bail? 1/2/2023.
Lord.
When did you inform?
On 6 to 2023, my lord.
And then
Nothing, my lord. No TP, no circuit.
Has to take instruction,
Out
my
of,
lord, whether
out of
suspension
same FI, my lord,
he has initiated. or not.
another principal was also arrested. He was also placed suspension. You lost it as reinstated him. They will reinstate him.
but did this court reinstate him without notice?
No, my lord.
Fantastic.
Short notice was given.
Or
And instruction was
Ms.
sought for.
R. Ali, the learned, Mr. R. Ali, the learned counsel for the petitioner. Madam, you are appearing for?
Higher education, my lord. Respondent number 1 and
Yes, your name?
PR Mohanto.
Ms. P.R. Mohanto appears on behalf of the respondent number 1 and 2. Issue notice. It's a short notice suspension matter. We'll have it on
2 weeks, my lord, after 2 weeks.
no. We will have it on not on 23. We will have it on 31st.
31st, my lord, first week of May.
Why?
Office,
You
I
have to
to
only find out. I'm not asking anything, whether you have followed the principle, because once he has informed, within 3 months, you have to submit your memorandum of charge. Have you done that?
Madam.
I'm not asking you to file an affidavit. We'll look into it. Once you do it, then I'll ask you to file affidavit if you need. Mr. appears for respondent number 1 and 2. It appears on record that the petitioner was arrested pursuant to an FIR dated, what is the date? 30/10/2022. In connection with, which was registered as Borpeta PS case number 1058/2022 under section 120B/468/471/420/417 IPC. It further appears that the petitioner was arrested on 24/12/2022, isn't it?
Lord.
Subsequent thereto, on 6th of January 2022, the petitioner was put under suspension in terms with Rule 6.2 of the Assam Service Discipline and Appeal Rules 1964. On 1/2/2023, in bail application number 201/2023, the petitioner was released on bail by this court. Subsequent thereto, on 6/2/2023, the petitioner duly informed the Director of Higher Education that he has been released on bail. The learned counsel, appearing on behalf of the petitioner, drawing the attention of this court to the judgment in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SCC 291, the division bench judgment of this court in the case of Rekibuddin versus State of Assam, reported in as well as the judgment of this court in the case of Rafed Ali versus so-and-so, reported in so-and-so, had submitted that the petitioner, having informed the respondent authorities on 6/2/2023, until the filing of the instant writ petition, as no memorandum of charge and or charge sheet has been served upon the petition. The further continuation of the suspension order was contrary to the law laid down by this court, by the Supreme Court in the case of Ajay Kumar Chaudhary, Supra. The learned counsel appearing on behalf of the respondent number 1 and 2 is directed to obtain instruction as to when the petitioner informed the said authorities that he had been enlarged on bail and or not in any custody or what is the he has been when he has been released on bail or is not otherwise in custody or imprisonment. This court further, the learned counsel for the respondent shall also apprise this court as to whether the memorandum of charge oblique the charge sheet has been served upon the petitioner and as to whether there has been compliance to the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary, Supra.
17. One thing, we may be given some liberty to upgrade the matter.
No.
The returnable data.
No, when I've said instructions, it will automatically come up. These are all instructions, you see.
Look.
When I say instructions, it will come up. When I say affidavit, it won't come.
Right.
Yeah.
In the year 2017, my lord, one scheme was issued by the government of Assam, my lord, at page 17, my lord, to provide certain benefits.
Modified issuance. Yes, then what happened?
Then, my lord, at page 20, the DO has issued an order, my lord, showing my name at serial number 7 to pay the state benefit, my lord.
Yes, then
Subsequently, my lord, we have submitted the representation, my lord, at page 35 and 37.
Then
But nothing has been
we
said.
we means you or I. We means how many?
I.
I. Well, that's then
And the matter is
nothing has happened.
nothing has happened, my lord.
So you want that your calculation of your pensionary benefits should be made by taking into account the benefits under the MACP.
Yeah, Mr. Joe.
That's your long and
Yeah.
short case.
Yeah.
Mr. M. Hussain,
Yeah.
the learned counsel for the petitioner. Mr.
For 1,
N.J. Khatonia appears on behalf of the
1,
respondent number 1,
2, 6 and 7.
6 and 7. Mr. Arbor Pujari appears on behalf of the respondent number 3 and 8. Ms. D. Deka appears for the respondent number 5, and Mr. S.R. Borua appears for the respondent number 4. Issue notice making it returnable on 30th of June 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 22nd of May 2023. The case of the petitioner herein is that the petitioner is entitled to the benefits under the Modified Assured Career Progression Scheme so notified by notification dated 6/7/2017. It is the further case of the petitioner that the district elementary education officer had also passed an order to the effect that the petitioner is entitled to the third MACP benefit with effect from 1/1/2017. However, the said benefit had not been given in spite of the fact that the petitioner had submitted various representation. In the meantime, the petitioner have already retired.
Retired. retired on my lord 31/12/2019.
Have already, in the meantime, the petitioner had already retired on 31/12/2019. It is therefore the case of the petitioner that the petitioner would be entitled to some area salary
Yes.
upon granting him the benefit in terms with the notification dated 6/7/2017, as well as the pension, as well as for recomputation of the pension after granting the said benefit. The respondents, more particularly in the elementary education department, is directed to apprise this court on the next date as to why the benefit of why the third benefit under the notification, in terms with the notification dated 6/7/2017, have not been granted to the petition.
Obligation.
18.
Yes.
My lord, in this case, my lord, leave salary and my lord, area revised pay has not been paid to the petitioner. Leave salary and area revised pay, my lord, with effect from 1/4/16 to 28/2/17 has not been paid to the petitioner.
Yes, Corporation Department. Tell me,
My lord, we need to seek
lawyer who wants to do matter on Saturdays. Tell me.
My lord, we need to seek instructions as far as grievances are concerned. Arrears, leave salary has not been paid. His leave salary as well as the arrear revised pay has not been paid from 2016 to 17, period of 1 year. His representation is on is in page 60.
Yes,
Commissioner.
Area revised pay.
Yes.
So this will be for this pay. When did you retire?
19 months.
Then why didn't you get this amount?
Yes, my lord, sir, kindly see my lord, page 57, my lord. I approach this honorable court. My lord, third round of litigation is going on. My lord.
How much?
Third round.
Okay.
When my lord, the
Third,
petitioner,
Mr. So-and-so Limited dispose of directing a pass a revision order under representation dated demand seeking for the consumer. Now, have they passed any revision order?
yes, my lord.
Where?
My lord, pension has been paid. Already pension has been paid, except this leave salary and my lord, this area revised my lord, pay. Rest are paid.
No. This aspect was not there before the earlier court, because the earlier court you were saying that you were subjected to this resulting in the order by which a penalty of withholding
Yes.
2 annual increment
Yes.
with cumulative effect was imposed on the petitioner. Being aggrieved, the petitioner was instituted, which was given a final consideration by which the order of penalty was set aside.
Yes.
An application for setting aside an order would have been the consequential financial would be also entitled if those were. As the consequence has not been given, the petitioner made a representation before the Imam seeking for Imam. So they have not passed any reasoned order.
Before that, my lord, they passed order. Kindly see page 48. My lord.
What do they say?
My lord, in this order, my lord, in view of the
Where is
compliance
the
of the
order
honorable court
dated
order,
wherein they had order to set aside the impugner in view of the compliance with the order of imposing penalty, killing so and so is hereby withdrawn with immediate. No, that is okay.
Yes.
This has been done giving effect to the earlier, the first round.
Yes.
The second round says that you were not given those benefits.
Yes.
So you were asked to submit a representation.
Yes.
Did you submit a
Yes, my
representation?
lord. Page 59.
Yes.
For consequence. Thereafter, my lord, pension has been paid. Everything has been paid, my lord, except
Where is the representation?
Page 60, my lord.
thereafter, my lord, page 60.
March.
Then how do you know that they are not going to act on this representation?
My lord, since, they have no, petitioner has not been paid, my lord.
Huh?
petitioner has not been paid, my lord.
This order was passed on 7/12/2022. You submitted the representation on 29/3/2023.
In the meantime, in 2023, they have paid my concern.
So you should be happy with that. So why you are not trusting them that they are not going to give you the benefit?
My lord, but leave salary and area revise there is nothing.
So they may give. First of all, where is your representation categorically mentioning about the leave salary? Where is it?
This is my lord, page 60, my lord. Page 60, my lord.
Area salary, area revised pay, emoluments, leave salary by application dated demand. After that, we are going to be pleased to release my dues under the head of area salary as well. The budget submitted to Balaji so and so.
Prayer is there,
But
my
it is brief to state here that though the complete budget was submitted, my leave salary along with area revised pay is not released till date. Therefore, kindly do the need. So how do you know that they are not going to do the needful? You only gave in the month of March last day.
Yes.
Then,
but they have not paid now.
so the third round of litigation by you
Yes.
is a luxury litigation. See?
I have notice to do it.
Notice?
Notice into election.
No, notice will go, no problem. Notice will go. The petitioner is also entitled. But the lawyer out here should also be compensated by you, Mr. Sohan. So every date we fix, you are to pay to both of them. What do you say? It should be done. Chalo.
Yeah.
So we put you every date, whenever the matter comes, we could impose you a cost of 5,000 to you. So the 2,500, 2,500 he gets.
Be able to a
Because
department.
you have unnecessarily approached this court. Couldn't you have waited for another 10, 15 days?
My lord, it was submitted on 29 2000.
Yes, 29. And 29 from then to today. And the amount of labor you have taken in making this entire petition, if you have taken that, been filing a more detailed representation, wouldn't have it been better? So cost on you, upon the council,
No, my lord.
5,000, 5,000,
Kindly, my lord.
5,000.
No,
Every day to
my
you.
lord, kindly.
Mr. R. Chauhan, the learned counsel appearing on behalf of petitioner. PNRD, you are PNRD.
PNRD, my lord.
When did you? I thought you were corporation.
PNRD, my lord. 1, 2,
Okay,
and
what
4.
is your name?
P. Hendig, my lord.
P. Hendig appears on behalf of the
Eight
respondent
one.
number 1 and 2. 1, 2, and
4,
4.
my lord. Yeah.
Mr. S.K. Methi appears on the behalf of the respondent number 3. The issue notice making it returnable on, you see, July. I can't help you. 19th of July, 2023. Steps be taken upon the, as the respondents are duly represented by their respective counsels, extra copies of the petition be served upon them by 22nd of May 2023. The case of the petitioner herein is that the petitioner have not been given the area salary with area revised salary with effect from 1/4/2016 to 28/2/2017. And also the leave salary amounting to rupees 7,63,280. In that regard, the record further shows that this court, by an order dated 7/12/2022 in WPC number 7854/2022, had directed the petitioner to submit a representation had directed the petitioner directed the Commissioner PNRD Department to pass a reason order on the representation so submitted by the petitioner on 1/10/2022 relating to the consequential financial benefits. The learned counsel appearing on behalf of the petitioner submits that that in spite of the order passed by this court on 7/12/2022, as the area revised salary for the period above mentioned and the leave salary was not paid, the petitioner submitted representations on 20/12/2022 as well as on 29/3/2023. It is therefore the case of the petitioner that in spite of the order being passed by this court on 7/12/2022, the petitioner the respondent authorities have not passed any reasoned order, nor have granted the consequential benefits. It is, however, submitted by the learned counsel for the petitioner that in the meantime, the petitioner have got his regular pension. On the returnable date, the learned counsel appearing on behalf of the PNRD department shall apprise this court as to what steps have been taken pursuant to the order dated 7/12/2022 passed in WPC number 7854/2022. And as to whether any reason order to that effect have been passed by the Commissioner PNRD Department. Pending disposal of the instant writ petition, it shall not be a bar on the part of the respondent authorities to pay the area revised salary as well as the lease salary if the petitioner is otherwise entitled.
19.
Yes.
The petitioner before Lordship, my lord, he was a PEO, my lord, got arrested, my lord, and he was put under suspension, my lord. The suspension order, your lordship will find at page 30, my lord.
Then,
my lord, 90 days has crossed, my lord. Till date, no charge sheet, nothing, my lord. Suspension order dated 25th of August 2020. And I have filed a representation, my lord, that your lordship will find at page 33, my lord, on 14/11.
suspension order is where?
Page 30, 30.
30.
30.
Where you arrested?
I got arrested, my lord, on 16/8/2022.
16/8/2020. Okay, released?
My lord, 90 days will be on, my lord, 23rd of
No, released.
released, my lord, on 19/9.
Annex 4.
Annex 4, page 27.
19/9. And then when did you intimate about the release order?
My lord, on 11th of November, my lord. Sorry, 23rd of November. 23rd of November, that your lordship will find at page 33. Sorry, 14/11. 14.
14th of November.
Yes, my lord. To the director, my lord, that is the appointing authority. And next page, my lord, on 15th also to the secretary also, my lord. Same representation, Annex 9, page 36.
Okay. Heard Mr. N.J. Doctor, the learned counsel appearing on behalf of the petitioner. Mr. B. Talukder appears on behalf of the respondent number 1, 2, 3, 4, and 5. Issue notice making it returnable when? 31st. 31st of May 2023. As the respondents are duly represented by Mr. B. Taluga, extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that an FIR was filed
On 16/8/2020. Page 20.
on 17/8/22 on the basis of which anti-corruption branch PS case number 28/2022 was registered under section 7A of the Prevention of Corruption Act 1988 as amended up to 2018. The petitioner was thereupon arrested on when?
17.
On 17/8/2022 itself. Agoto FIR was filed on 16/8. Huh? 17/8/2022 itself. It further appears from the records that on 19/9/2022, the Court of the Special Judge Assam granted bail to the petitioner. Full stop. Subsequent thereto, grant to the period. Full stop. In the meantime, the disciplinary authority, that is the Director of Elementary Education, had issued the order dated 25/8/2022, thereby exercising the powers under Rules 6.2 of the Assam Service Discipline and Appeal Rules 1964 and suspended the petitioner pending withdrawal of departmental proceedings. First. The petitioner, upon being released on bail on 19/9/2022, had submitted a representation to the Director of Elementary Education Department on 14/11/2022, seeking reinstatement on the ground that no reinstatement of on the ground. Where is your statement out here that you have been released on bail?
Release on bail, my lord, page 33, my lord, first paragraph, my lord, 1, 2, 3, 4th line, my lord. Thereafter, I was
intimating that he had been released on bail on 21/9/2022.
It was a typographical mistake. It should be 19/9. I was released on bail on 19/9.
It is the case of the petitioner hearing no. Further to that, the petitioner had also preferred an appeal before the Secretary to the Government of Assam Education Department against the suspension order. However, it is the case of the petitioner that no steps have been taken in respect to the said appeal. Be that as it may, it is the case the learned counsel appearing on behalf of the petitioner had submitted that in view of the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, which was duly applied even to cases of deemed suspension by the division bench of this court in the case of Rekibuddin versus State of Assam, reported in so and so, as well as the judgment of this court in the case of Rafid Ali versus State of Assam, reported in so and so. The petitioner having intimated the respondent authorities that he has been already released on bail and is not otherwise in custody or imprisonment, the further continuation of the suspension order dated 17/8,
Yes, ma'am.
2022. 25/8/2020, without serving the memorandum of charge or charge sheet upon the petitioner, is in violation to the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary. The learned counsel appearing on behalf of the respondent elementary education department shall apprise this court as to whether the petitioner had duly intimated that he had been released on bail, and if so, when. Further to that, the learned counsel for the elementary education department shall also apprise as to whether the petitioner have been served the memorandum of charge and or the charge sheet, and as to whether there has been compliance to the law laid down by the Supreme Court in Ajay Kumar Chaudhary.
Can I add one more, my lord? In addition to that, Ajay Chaudhary, my lord, so far, my lord, the manual of the departmental proceeding, my lord.
2.18.
Yes, my lord, that.
2.18 will minimum and all these things. That is a different.
My lord. It takes 3 months automatic, 90 days.
2.18 comes on the basis of FR 53.
Yes.
Because you have to normally pay him 50%, otherwise you have to increase. You are allowing a person to work out there without a salary. You are giving him 75% of the amount and you are not getting work. So that is the reason why in 2.18 on the top portion, it not only affects the delinquent employee, it also affects the state revenue.
I'm obliged.
Okay.
20.
Yes, leads to non-payment of salary. Petitioner before lordships were teaching and non-teaching staff of Mulua High School were appointed on 4th January 2021. Annexure 1, page 14, madam. 15 is details post. Then
this under new appointment.
Yes,
then,
madam. Then since then they did not get salary.
Why?
Inspector.
You are the headmaster.
Yes, I am not only I am headmaster. All the
your name is what?
Yes,
Munmoti Borsoikia.
Yes.
Yeah.
Then Lordship kindly turn annexure 2, page 16, my lord. The inspector school appraised details, my lord, to the director of secondary education. But nothing has been done till today. Accordingly, we have the Monomuti has submitted the.
Yes, why haven't you paid? You're giving people jobs right, left, and center and have no money to pay.
I'll obtain instruction, my lord.
When?
Short notice, my lord. 2 weeks.
Heard Ms. K. Devi, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Katonia appears on behalf of the
secondary division, my lord.
On behalf of the respondent number 1, 2, and 3. Issue notice making it returnable on 12th of June
Yes, my lord.
If the respondents are duly represented by Mr. N.J. Khatania, extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that petitioners were appointed on by an order dated 4th of January 2021. In the Molua High School,
MOLUA.
Molua High School,
High
in the
School,
district of
Golaghat.
Golaghat, with effect from 1st of August 2021. The inspector of schools, by the communication dated 7/9/2021, have also intimated the Director of Secondary Education that the petitioners herein have not been paid their salary. The petitioners thereupon have also approached the authorities and on 16/2/2023 have also approached the inspector of schools that they have not yet received their salary. The learning council, appearing on behalf of the respondent elementary education department, shall apprise this court on the next date as to why the salary has not been paid to the petitioner since their date of their appointment.
Obliged.
Item 24 and 25.
Yes, Mr. Mehdi, you are appearing for central government?
We have no, my lord, specifically 2 and 3, the director and take instruction, my lord.
Then what happened?
And Mr. Konikar.
Why the matter has come after such a long time?
Huh? Oh.
You were asked to obtain instruction on 6/9/2022. What happened?
2 and 3. 2 and 3, my lord. Accordingly, they have filed their affidavit.
Who is appearing for 2 and 3?
Konikar, my lord.
He appears for whom?
2 and 3, my lord.
What is that 2 and 3?
2, 3,
Central Inland Water Transport Organization Corporation.
yes, my lord. And
Ministry of Shipping. Who is appearing for that?
I'm okay. My lord, in
So what is your stand?
my lord, in court, WPC 44 5/2006, I'm appearing. Other my lord, my lord.
Mr. Mehdi, are you aware of the fact that you are appearing for a respondent?
Yes, the respondent 1, my lord.
And for that you have filed an affidavit.
Yes, my lord.
What is your affidavit? He's asking for the IDA pay scale from 2007, from 1/7/2007.
Yes.
Whether he's entitled or not.
My lord, so far the affidavit, my lord, is not, my lord. And there is your lordship may. This is paragraph 5 of my affidavit, my lord. taking the PRS, so for PRS, director thing is that,
IVR.
IVRS. IVRS, the last occasion, we can take instruction.
You were working in,
CIWT, Central Indian Waterway Transport Corporation.
so they have not adopted the IDA scale.
Yes, IVRS. Now we are opting for IVRS scale, and accordingly,
But that, as per the affidavit filed by them,
they have not filed any affidavit in this.
no,
WBC.
they have filed the affidavit. The government has filed an affidavit.
And his
No, you have filed an affidavit.
Yes, ma'am.
And as per their affidavit, it is clear that this company have not implemented the ITA pay scale. Since ITA pay scale was not implemented in the company. Then,
No speaking.
yes, Mr. Koniga, what have you done in terms of the instructions sought for?
I have filed an affidavit, madam. This is my affidavit, madam.
What does it say?
On 31/3/23, madam. Madam, regarding madam, case number 6248, madam. WC number 6258. I filed, madam.
We are concerned with 4450.
No, 445 is something different, madam. This is relating to not termination, madam. IVRS code.
No. 4450 is for ITA scale.
6258, this is IVRS. In the order, madam, it is wrongly reflected, madam. In the both cases, madam, this order has been passed in 44, madam. But regarding IVS, madam, case number is 6258.
Mr. Koniga, do you have a copy of the repetition in WBC number 4450? Then read it. Read the prayer. Isn't that the prayer for IDA scale?
Regarding my petition, madam, this is not met. 4450, madam. This is regarding my IDA pay scale.
That is what I'm asking you.
IDA, madam.
Then
Madam, no, IVRS, madam.
I'm on IDA pay scale.
IDA. Madam, related to IDA pay scale, madam, there are another 2 cases pending, madam.
I'm not on that. I'm only asking you. There was a direction passed by this court that you are going to represent before the central government for something. What has happened there?
I'm not central government. I'm not ICW.
Understood. That is what the order was, that you are going to represent before the central government. Mr. Koniga, the learned counsel for response number 2 and 3 by referring to the previous order dated 23/8/2022. And on the basis of the instructions he has received, has submitted that the extension of the IVRS scheme for the petitioner would not be possible without the approval of the central government. And the Central Inland Water Transport Authority intend to write to the central government in this regard, seeking its view as to whether the IVRS scheme can be extended to the petitioner. Mr. Gana has submitted that in order to obtain such instruction, he will require 4 weeks. That is why the matter has come.
Relating to IVRS, madam.
Okay, what is this idea?
This is idea, madam. This is something different.
Okay, what
This
is
order
your,
has been passed.
no, what is your stand as regards the idea?
Idea, madam. I have filed an affidavit, madam.
What is it?
We have filed, madam. We have filed 2 affidavits,
There
madam.
is an additional affidavit
Additional
filed by
affidavit,
you.
madam. In this regard, madam, Calcutta High Court, madam, has passed out
Idea
on
is-
dismissing
What
his-
does it say? That the deponent said that the aforementioned petition has been filed, but we are paying for the direction for IDA scale with effect. The deponent said in similar lines, 10 petitions were filed before this court, and the further states that all the aforementioned were filed in similar line, and the relief for in the above time for ADS form is revision in CTA pattern and IDA paper. Deponent says the aforementioned were finally heard by the Honorable High Court at Calcutta as dismissed. So you are saying that the Calcutta High Court
Has this-
order.
No, I have filed this is additional affidavit. Relating to writ petition, I have filed affidavit. You have filed.
Why was it dismissed?
Not dismissed, my lord, we are retrenched by way of forced retirement. Forced retirement, we are retrenched, of course. That you, if you are not opted for
My lord,
IVRS,
this is something confusing, my lord. Relating to WC number 4450, this is relating to IDA, my lord. And my
Okay,
lord,
let us first take up
44.
IDA.
No, he is submitting a forced retirement. Forced retirement.
Post retirement will go later
But-
on, but Mr. Counsel, you know your brief, I suppose. What is this IDA pay scale?
IDM means industrial dearness allowance.
IDA.
I,
So you say that you are entitled to
yes, from 2007.
from 2007. Why?
Because that idea scale was adopted in the year 2007 by CIWPC.
Where is it?
A business statement is
Akir Alam. In terms with the board resolution following are hereby transferred and released with immediate effect. And they have to report the working place of so and so Jogi Gopal. Implementation of the improved voluntary retirement. This is IVRS 2015. IVRS scheme for employees of Central Region. Why there are two petitions by the same person?
My lord, one petition is against my retrenchment. In spite of interim order
Okay.
passed by this honorable court, they are not complied with the interim order.
Okay, so that is it.
Yes.
But what is your, how are you claiming on the IDA?
IVRS,
IDA.
ID.
Isn't your first petition claiming IDA?
Yes, ma'am.
Why are you claiming that? Show me the document.
Document.
So your document is 18th of May 2016.
My lord, then if lordship may kindly come to 5th February 2015, my lord.
Eh?
Page 14, lord.
Page 14. Yes.
Para number 4, my lord.
Hmm.
Other terminal dues, that is leave encashment and gratuity, would be calculated as per revised CTA pay scale 2006 for employees covered under CTA pay scale and revised ITA pay scale 2007 for other categories of employees.
Now, were you covered under the CDA or the CDA or not?
Lordship may kindly take up the matter next week.
No, no, no.
My lord,
2016 matter, it doesn't look
it is
nice.
there, my lord. Actually,
This
what
court
happened,
doesn't
just
grant
early in the morning, I
adjournments in
jumped
these matters. It is made clear because you see the Ministry of Shipping's affidavit is clear. The company has not taken IDA. And then if you see, then the page 22 of your affidavit of the petition makes it further clear. This is for your information that CIWC revision of IDA pay scale could not be implemented in terms of DPA circular since there is a loss-making company. So under such circumstances, if the company has not adopted that, how can you be entitled to the IDA pay scale? You take the other matter on a different note, but this matter, how can you get it? When the authority have not implemented it, how can you do that? And you were retrenched in 2007. When?
2016.
2016. The employees covered under the IDA pay scale and other pay scales were entitled to great ex gratia and other retirement benefits equivalent to IDS in the event of opting for IVRS. It is those people who have opted, who are covered under the IDA pay scale. When the IDA pay scale was not implemented, how do you get the benefit?
He has not accepted IVRS till then. He has not accepted IVRS.
No, IVRS is a different thing. First and foremost, the IDA pay scale has to be adopted. It has to be, they have to be covered under the IDA pay scale.
They have said that they are loss-making company, so they are not inclined to take
So how can you? Because they have the authority to do that. That we may not accept. We're being a loss-making company. We are not in a position to do so. That they can very well do it. Heard, mister?
Yes, to.
Your name?
Yes, to.
Yes.
Yes, to.
H. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. S.K. Methi appears on behalf of the Central Government Council. Mr. A. Konikar appears for the respondent number 1 and 2.
2 and 3.
2 and 3. The case of the petitioner herein is that the petitioner was initially appointed as a record keeper with effect from 1/10/1990. In the respondent number 2 organization. Thereupon, the petitioner, by an order dated 6/4/2015, was transferred to Jogigopai in Bongaigaon district, where he had joined on 9/4/2015. Upon the recommendation, pursuant to the recommendation of the 6th Pay Commission, Central Pay Commission, the revised pay structure was implemented for the central government employees with effect from 1/1/2006. It is the case of the petitioner that the respondent number 2, though have adopted the revised pay structure in the terms of the recommendation of the 6th Pay Commission, but did not implement the same until 2007. However, subsequently, the revised pay structure with industrial DA pattern, bracket IDA, was implemented partially in CIWTC in the respondent number 2 organization with effect from 1/1/2007. But the benefit of the revised pay was not granted to the petitioner. And the petitioner was continued in the old revised scale of pay with IDA, which is equivalent, which is evident from his salary statement enclosed to the instant petition. It is the further case of the petitioner that the respondent number 2 organization had introduced a voluntary retirement scheme for its employees. However, as the voluntary retirement scheme was not attractive, the respondent number 2 organization introduced an improved voluntary retirement scheme bracket IVRS for its employees by notice number 02/2015 bearing SECY/53 bracket 1/123 dated 5/2/2015. In terms of the IVRS package, it was provided that the employees covered under the Central Dearness Allowance CDA pay scale could be entitled to get ex gratia and other retirement benefits equivalent to the pay scale of the CDA pay scale 2006 in the event of opting for the IVRS. It was further mentioned that the employees covered under the Industrial Dearness Allowance bracket IDA pay scale and other pay scales would be entitled to get ex gratia and other retirement benefits equivalent to IDA pay scale 2007 in the event of opting for IVRS, which is evident from the notification dated 5/2/2015. At this stage, before further proceeding, this court deems it proper to take note of the notification dated 5/2/2015 issued by the chairman cum managing director of the respondent number 2 organization. In clause 4 of the said notification, it has been categorically mentioned that other terminal dues, that is leave encashment and gratuity, would be calculated as per the revised CDA pay scale 2006 for employees covered under the CDA pay scales and revised IDA pay scale 2007 for other categories of employees. Further to that, in clause number 1 of the said notification notice dated 5/2/2015, it has been mentioned that under the improved voluntary retirement scheme 2015, the calculation of the basic pay and the DA would be as per the revised CDA pay scale 2006 for employees covered under the CDA pay scale and revised IDA pay scale 2007 for other categories of employees. It is therefore the case of the petitioner that the petitioner is entitled to the IDA pay scale of 2007 with effect from 1/1/2007, for which the instant writ petition has been filed. It appears on record that this court, by an order dated 29/7/2016, had issued notice making it returnable by 6 weeks. While taking up the instant writ petition for adjudication, it further appears from the records that the respondent number 1, that is the respondent number 1 through the deputy director had filed an affidavit on 5th of April 2000, 6th of April 2018. From a perusal of the said affidavit, and more particularly at paragraph number 5, it transpires that by the Department of Public Enterprise Guidelines dated 14/10/2008, it was made clear at paragraph number 3 that the benefit of pay revision may be allowed only to employees of those CPSEs that are not loss-making and are in the position to absorb the additional expenditure on account of pay revision from their own resources without any budgetary support from the government. It was further mentioned that the respondent number 2 organization was a loss-making organization since inception and was not in a position to absorb the additional expenditure on account of pay revision from its own source. In paragraph number 9 of the said affidavit, it was further mentioned that the employees who opted for IVRS 2015 only got the benefit for fixation for the purpose of formulating of the IVRS benefit only. And in case of employees under the CDA pay scale who opted for IVRS also got the benefits for the purpose of calculation of the IVRS benefits in terms with the CDA pay scale 2006. It was further mentioned that in case of employees under the IDA pay scale who opted for IVRS got the benefit for the purpose of the calculation of the IVRS benefit in terms of the IDA pay scale 2007. But actual revision of pay scale was not implemented in the company, in the respondent number 2 organization, and no arrear was paid. In paragraph number 10 of the said affidavit, it was further mentioned that the prayer for the petitioner for IDA pay scale cannot be considered in view of the fact that the respondent number 2 organization did not implement the IDA pay scale. It was further mentioned in paragraph number 13 that after the implementation of the IVRS in the respondent number 2 organization during 12/1/2015 to 10/4/2015, out of 272 numbers of employees, 267 were released under IVRS, and only 5 numbers of employees remained on the roll since 10/4/2015. In paragraph number 15, it was mentioned that the upgradation of the petitioner have been considered with effect from 4/10/2000 in lieu of 1/1/2014, and the area amount has been paid to him by check number 192104 dated 4/3/2015. The said affidavit, the petitioner had submitted a reply. in the to the said reply, an office memorandum dated 26/11/2008 was enclosed. Which was issued by the Ministry of Heavy Industries and Public Enterprise. In terms with clause 3 of the said office memorandum, it has been mentioned that a revised pay scale would be adopted subject to the condition that the additional outgo by such revision for a period of 12 months should not result in more than 20% dip in profit before the tax bracket PBT bracket close for the year 2007-8 of the CPSC in respect of the executives as well as the non-unionized supervisory staff taken together in the CPSC. It further appears from the records that the respondent number 2 and 3 have also filed an affidavit in opposition. The stance so taken by the respondent number 2 and 3 is similar to the affidavit in opposition filed by the respondent number 1. But relevant herein to take note of that in paragraph number 10, the respondent number 2 and 3 have categorically stated that the application of the petitioner praying for a new pay scale of 2007 could not be considered since IDA pay scale 2007 was not implemented in the company. The DP office memorandum dated 14th of October 2008 was enclosed as Annexure A to the said affidavit filed by the respondent number 2 and 3. Further to that a notice number 1/2005-15 dated 12th of January 2015 was enclosed as Annexure B which pertains to the implementation of the Improved Voluntary Retirement Scheme 2015 for employees of the respondent number 2 organization. Relevant to take note of that in the said notice dated 12th of January 2015, it was categorically mentioned that the Improved Voluntary Retirement Scheme 2015 would be in accordance with the 6th Central Pay Commission recommendation equivalent of pay scale of the central government employees with effect from 1/1/2006 CDA pay scale and the Industrial Dearness Allowance bracket IDA pattern of pay scales with effect from 1/1/2007 for employees covered under the IDA and other pay scales, that is bipartite settlement of floating staff bracket crews and tripartite engineering wage settlement covered under TEWS. Further to that, the respondent number 2 and 3 have also filed an additional affidavit on 1st of September 2020, wherein there was a mention that similar writ petitions were also filed before the Calcutta High Court, which were however dismissed by the judgment and order dated 10/12/2019 pertaining to the same issue. I've heard the learned counsel for the parties and perused the materials from the court. It appears from a perusal of the orders so passed by this court that the instant writ petition was tagged along with with another writ petition, that is WPC number 6258 of the 2016. However, upon a perusal of the materials, however, upon a perusal of the reliefs claimed for. However, upon a perusal of the pleadings as well as the reliefs claimed for, both the writ petitions are distinct and different, although the petitioner may be the same. In the backdrop of the above, therefore, this court takes up the present writ petition for disposal. From a perusal of the writ petition, it transpires that the claim of the petitioner is based upon the IDA pay scale 2007. The writ petitioner have not challenged the DP Office Memorandum dated 14th of October 2008, which categorically mandates that the benefit of pay revision may be allowed only to employees of those CPSCs that are not loss-making and are in a position to absorb the additional expenditure on account of the pay revision from their own resources without any budgetary support from the government. The petitioner have also not challenged the notice dated notice number 02/2015 dated 5th of February 2015. The notice number 1/2015 dated 12th of January 2015, wherein it has also been categorically mandated that those persons who are enjoying the CDA, central government, those who are enjoying the CDA pay scale would be entitled to the benefits in terms with the CDA pay scale, and those who were enjoying the benefits under the industrial dearness allowance pay scale, pattern of pay, with effect from 1/1/2007, would be entitled to the VRS benefits, IVRS benefits in terms with the IDA pay pattern. The petitioner have also not challenged the notice number 2/2015 dated 5th of February 2015, wherein also it has been categorically mentioned that the improved voluntary retirement scheme 2015, the calculation of the basic pay and DA would be as per the revised CDA pay scale 2006 for employees covered under the CDA pay scale, and the revised IDA pay scale 2007 for other categories of employees. The petitioners further have not also challenged Annexure number 8, Roman 8 of the writ petition, which was issued to the petitioner, whereby it was informed that the IDA pay scale 2007 was not implemented in terms with the DPA guidelines, since the respondent number 2 organization was a loss-making company. Be it as it may, the petitioner have not been able to show in any manner that the petitioners were covered at any point of time under the IDA pay scale of 2007. The fact that the respondent number 2 corporation is a loss-making unit have been specifically stated in the affidavits filed by the central government as well as by the respondent number 2 and 3. The fact that the IDA pay scale 2007 was not implemented in the respondent number 2 corporation has also is a specific and categorical stand taken by the respondent number 2, by the respondents herein. The learned counsel appearing on behalf of the respondent number, who wants? Both of you? Whose submissions to the record? You. Okay. You are the first. The respondent, the learned counsel, Mr. S.K. Mehdi, further drawing the attention to the judgment of the Calcutta High Court, have also drawn the attention to the fact, paragraph number 29, which shows the state of affairs as regards the respondent number 2 organization. To the effect that the funds of the company funds of the respondent number 2 corporation have been being in a dilapidated, to the effect that the respondent number 2 corporation being a loss-making unit, the funds of the respondent number 2 corporation has been deposited in an escrow fund fixed deposit upon the directions of the Union Cabinet after the disposal of the surplus assets and properties of the corporation. In that view of the matter, as the IDA pay scale, pattern of pay 2007 was never implemented in the respondent number 2 corporation, or for that matter, the petitioner having failed to show that the IDA pattern 2007 was implemented in the respondent number 2 corporation, or for that, or the petitioner was enjoying the IDA pattern pay scale of 2007. This court does not find there is any merit in the instant writ petition, thereby to direct for grant of benefits in terms with the IDA pay scale 2007 to the petitioner. Accordingly, the petition stands dismissed. Yes, now come to the second one. Here you have been.
My lord, here is
Yes, what? Yes, Mr. Konigar. What has happened to this IVRS thing?
And I have, in this regard, I have filed an affidavit. Additional affidavit.
Very good.
Matter on 31/3/2021.
I am now the company secretary to the central so and so in my official. I have been taking steps in IVRS was implemented in year 40 months from so and so. Yes. Now what happened?
Now, Lord, even my lord, we have.
Have you written it to the
Madam,
central government?
Madam.
What does the central government say?
No, my lord, no reply.
What?
They want to keep silent.
Sir, in this case, since we have not received any instructions to notify.
Huh?
Sir, in this case, we have not received any instruction, therefore affidavit should not be filed.
I am not concerned with who, what instruction, which instruction comes. This is a matter of 2016. Then?
But this is the letter we have written.
No, if you have retrenched, just for example, let us assume you have retrenched them. What was your position?
at that time.
Huh?
At the time of retrenchment, my lord, I was working as
You don't know.
no, my lord. That's
Record keeper.
the record keeper, my lord, in the year 1990.
Who? All these are grade 4. Mr. Counsel,
Yes, sir.
would you come within the ambit of workmen?
Workman.
Okay, then why not 33J or A of the Industrial Disputes Act wouldn't apply for them? Second, you say industrial dispute. Tell me. No, when you retrench somebody, are you not entitled to, you are liable to pay them something? What have you done?
Initially, my lord, what happened, my lord? VRS scheme was initiated.
Understood.
And then
No,
IVRS, my lord.
I've read it.
My lord.
I've read your file now.
And then, my lord,
You
Sir,
see,
Madam
your
Chairman,
specific stand out here is there was a VRS, nobody opted. IVRS, many have opted, 240 or 50 have
Only five
opted,
deputy.
and they have been given the benefit. And there is another person out there. There were few persons who did not opt, so that the
Only
central
5%.
government again took up another decision and gave a window of 1 month. Did you put him to notice
No,
that within 1 month you do it?
there are two notices we have served.
Okay.
We
Now,
have to-
after that,
After that, Madam, we have written.
retrench. Now, what happens when you retrench? Have you paid him something?
No.
Something? Then can you retrench in that manner? Because the law otherwise says something else. 33. Recovery. Retrenchment is section. How many petitioners are left out?
The 5 people.
So those are the 5.
Same, those are the 5.
Those are the 5. So in the earlier round of earlier litigation, you were not asking for the IVRS.
No, that's no point of
Then why you were asking for this IDAP scale?
some benefit, much more benefit than that. See. But I have to pray for that. IVRS can be given to me. Now,
No, tell me, Mr. Koniger, or whoever has retrenched, you or you, who have retrenched, you have done it.
No, not that.
No, you have done it at his instruction.
Madam.
Then, yes, madam, come.
Central government is the now competent authority. Madam.
Yes.
Right?
No, that is
Now we
why.
are in a
No,
house
no.
question.
I understand, Mr. Koniger, you have not done anything. You have done at the instruction of the central government. Let us get hold of the central government. Central government has a lot of money. Yes.
Since we have not into no instruction, so
No, then what can be done? You, which department is it?
this is shipping
Ship. The shipping has filed an affidavit in that other matter.
lordship.
Why not here?
Lordship, it was communicated, but shipping has referred it to someone else. Lordship, after that, no instruction has received.
Well, so whom should we ask the personal appearance? As
Lordship,
they are not coming because it's a 2016 matter.
Lordship.
So whom should we ask the personal appearance? Tell me.
Some more time maybe lots to give.
For what?
I will try lordship
Monday?
Monday.
Monday?
No, lordship, Friday or
Monday?
Monday, lordship, only one day.
So some more time is Monday? Wednesday?
Lordship. That's why I will try.
On that day, you give us the name of personally. We don't need
Not,
that.
not for personal offenses.
We will ask the person because no instructions have come, so personal opinion.
I'll try to.
The reason is why out of 72 employees, 267 employees have got. Assuming these people are to be retrenched, are you going to not pay a single penny? Can you do that? They're entitled to something.
No.
And if those persons are, there is only 5%. And if the petitioner is now willing to go for this IVRS, why not give it to them? The same benefits which those persons have got it. Get that instruction.
No.
I'm recording it in my order. You get your instructions on that.
No.
Heard, Mr.
Yes, sir.
To answer the learned counsel for the petitioner, Ms. RTP appears on behalf of the respondent.
Number one.
Respondent number 1. And Mr. A. Khanikar appears on behalf of the
Number 20.
respondent number 2 and 3. In the instant writ petition, the instant writ petition is of the year 2016. Although the respondent number 2 and 3 have filed the affidavit, but the respondent number 1 have neither filed an affidavit, and the learned counsel appearing on behalf of the respondent number 1 submits that she has no instructions, that no instructions have been given to her. The issue involved in the instant writ petition is that the respondent number 2 organization have initially floated a voluntary retirement scheme. However, as the terms and conditions of that voluntary retirement scheme would not be implemented as terms and conditions being not acceptable, a fresh voluntary improved voluntary retirement scheme was floated in the year 2015. Out of 272 employees of the respondent number 2 organization, 267 employees have already accepted the IVRS.
254 out of 254.
250? Four, how many have accepted?
240.
240?
7 has accepted.
Only 5 remain.
Only.
Then how can 3 and
No, not
that will be there? No.
not filed. They have calculated wrong.
No. They have given it in their affidavit. Okay. The affidavit of which? Remember it.
Must be 7.
Yes, I'm not wrong. No, Mr. Counsel, I never forget. Out of 272 numbers of employees, 267 were given an IVRS. However, 5 employees, that is the petitioner here, however, 5 employees did not accept the IVRS. Out of these 5 employees, the petitioner happens to be the 3 employees who have not taken the IVRS. The respondent number 2 and 3 submits that in view of, as would be apparent from the affidavit in opposition filed by the respondent number 2 and 3, as well as also from the additional affidavit, that in view of the specific directions issued by the Department of Industries, Public Enterprise, Government of Assam, Government in India, these 5 employees who had not accepted the IVRS were retrenched without giving any benefit. This court had put a specific query upon the learned counsel appearing on behalf of the respondent number 1, as well as also to the respondent number 2 and counsel appearing for the respondent number 2 and 3, as to whether the petitioner's hearing would not be entitled to any compensation in view of their retrenchment. And further, whether the petitioners now cannot be given the same benefits which have been already given to those employees, those 267 employees. The learned counsel appearing on behalf of the respondent seeks for an instructions, taking into account that the matter pertains to the year 2016. This court fixes this matter on 5th of June. It is made clear that if the instructions are not received from the respondent number 1, 2, and 3 in this regard, the person concerned who is responsible to give instructions would be called for, would be the personal appearance of such person would be ordered on such date as this court may fix on such.
The employee suffered injury while he was serving in Arunachal Pradesh. And thereafter, he was treated in various hospitals but could not recover. As per their contention, they have paid the salary up to January 2006.
They paid the salary till
January 2006.
Hmm.
Thereafter, they have not paid that. My case is before Lordship. As he got injury while he was serving in Arunachal Pradesh and residing at the camp arranged by the respondent. So my contention before Lordship that him to be got injury while he was on duty. He got the injury as a alleged manner, it's stated by the respondent in the affidavit manner by falling on at the night manner at 10 p.m. They want to say that he was intoxicated. By my case before Lordship that earlier to 2006, there are no allegation that he was anyway drunkard or any. Whatever has arises the contention matter responded by the respondent that were after the head injury matter. I want to take to your Lordship to
no, after the incident happened in 2005 or
2003 matter.
Huh?
2003 incident.
Did you inform the authority that
No, he was on duty. They have treated the respondents have treated the employee matter. They have taken to the hospital and got given the treatment, etc. They have done. At that time, the family was not with him.
And for how long did you work?
He was working since 1984.
84 to 2005.
6 months. 6 as part
From
of their
5,
contention.
5-6 Lordship.
Okay.
Yes,
Five,
sir.
or let us
Six.
assume
They have
5 or 6.
They have
No.
stated that they have
Whatever may be, let us assume that 2005 is they say
he said they are
now a person having worked for 16 plus 5 years, 21 years, is
Right.
not entitled to anything.
Lordship has already heard this matter, and accordingly, on the basis of our submission as well as the averment made in the affidavit, Lordship has directed them to file an affidavit enclosing the affair because he is missing from 2015. Our specific stance that he will get the retirement, his petitioner will get the retirement benefits subject to the drawing of presumption by the competent court. Lordship.
He has filed an FIR.
Yes,
My- well, my
Lordship, but regarding Lordship, that period wherein he was absent, unopposed absent, Lordship, there is no work, no pay.
it's okay for that, but what about the other?
Lordship, he will get, Lordship, may kindly peruse the paragraph 29 of our
No, if
affidavit.
he has gone missing from 2005,
2015. And from
2015.
2005, Lordship, he is unauthorized absent. 2 times he was punished for it also, Lordship. And there is also, they have filed also reply, therein also they have admitted that he is alcohol related.
No, my lord, I have not admitted. Why you are saying that?
I also.
Don't make wrong sound.
Paragraph 29. Affidavit filed on Lordship 19/3/2019 by Respondent 1.
27, this one, 29.
29. You will get, Lordship, petitioner will get PF, gratuity, as well as the 2 pension, Lordship. Lordship knows that Oil India Limited 3 pensioners there, Lordship. One Oil India Pension Fund, EPF 1995, as well as the Oil India Superannuation Benefit Scheme. Since he was appointed after 1981, Lordship, on the appointed date, Lordship. Therefore, he will get EPF 1995 as well as the Oil India Superannuation Benefit Scheme. So 2 pension he will get as well as the PF and gratuity.
So why haven't you given that?
Lordship, because from 2015 he was missing. Therefore, presumption has been drawn. We have filed this affidavit on 2019, Lordship. Therefore, they have not taken any steps to get an order from complaint court, Lordship, regarding the missing of the husband under 108 of the Evidence Act.
Now, the question is, if he is an unauthorized leave,
yes,
can he continue to remain in unauthorized leave for all that?
Yes. He was unlawfully absent, Lordship.
No,
On a security ground, Lordship, we have.
Mr. Kolta, that is not my question. My question is, if a person is in unauthorized leave, what action is being taken? What action does oil take?
Lordship, oil ought to have terminated him, Lordship.
If you are not terminating him, neither you are drawing up any disciplinary proceeding, then what happens?
But Lordship, there are several judgment of, because unauthorizedly absent, and we have issued the so cause notice also, that was also published in the paper publication. They have also replied. The petitioner replied. Petitioner's husband was missing. Lordship.
Where is it? So cause notice.
My lord.
Initial so cause notice, earlier he was punished 2 times, Lordship, due to his alcoholic problem, Lordship.
No, I'm not concerned with
Thereafter,
Let's see page 18.
First so cause notice, Lordship.
Page 18.
Yes, Lord.
In absenting from duty without authorized leave, so and so. You have been mentioned not as act alleged to have been committed by your amount to be misconduct. When you are therefore given to submit your return as honor before prosecution. Should you fail to submit any time, that we have no action.
Hereafter also, please
Medical advice. We are sorry to inform you that your health has been badly affected by thinking of. This has happened. This so-called notice, this annexure 4 is dated 2012-2005, after the so-called notice.
So there is second so-called notice also there.
Page 18 and page 19, if you look into it. Annexure 3,
yes, sir.
R3 is the show cause notice,
yes, sir.
that is dated 22/8/2005.
Yes, sir.
And the medical advice is of 2012-2005, after that.
Medical advice also.
It's a part of it, na? Page, see annexure R4. The next page. After the show cause notice. This is your document. I am not building.
Not a part.
Not a part. It was subsequently.
Yeah. So this happened subsequent. Then the another one is 2212.
Yes, sir.
Then on 1993-2000, we have find that you have failed to submit in this way, it would be justified to take appropriate disciplinary action against you as per the modified orders. However, we have decided to be generous and merely record an official warning against you on this occasion. We hope you will appreciate the generosity if you wish to avail the opportunity under the section 21 modified so and so. Then annual increment. As per advice so and so, your annual increment due has been withheld. Annual increment have been withheld on account of poor attendance. What is this poor attendance?
There is no attendance, Lordship. Unauthorizedly absent, Lordship. Therefore,
What is poor attendance?
because his payroll was not deleted, Lordship.
So cause notice.
This was published.
You are hereby
Uh,
given an opportunity to submit your error within 10 days after receipt of the return on demand, whether which is earlier, as to why disciplinary action should not be taken against you. Sections of here. Should you fail to submit your return action within the aforesaid time, it will be presumed that you have no explanation. Well,
No action.
what action have you taken?
This was published. They have also annexed it, Lordship, in replace on page 19.
Mr. Maheshwari, did you write anything on this against these replies?
At that time, he was in custody.
Huh?
He was in custody. In connection with, he assaulted his father, mother, because of mental condition. Thereafter, he remained in so times, my lord, so many months and years, my lord, in mental hospital because of health injury. He got in 2004.
Then when did you reply?
My
He
wife,
has not replied, Lordship. He has not, his wife has
wife of
replied,
the
Lordship.
employee replied, my lord. That
Well.
immediately, my lord, I took it. Good check. Huh?
Where is that document?
That I'm
Evidence.
Annexure 7, page 20.
Annexure?
7.
Writ petition.
My
Evidence.
Thereafter, filed various representation, my lord. Whether petitioner can be given any voluntary retirement or retirement benefit, whatever.
No, retirement benefit you will get it. No
No,
problem. I am not
no,
on
my
that.
lord. Whether he can be prematurely retired from this country. I want.
No, you will be getting 21 years. What do they get it? How much would he get it? He has rendered 21 years of service as per you.
Lordship, yes, sir.
My contention before lordship.
Because we have to calculate, Lordship, may fix the matter next Tuesday, Lordship. I will give the start, Lordship, how much he entitled, Lordship. Lordship, may fix the matter on Tuesday, Lordship.
What are the benefits he is
Yes.
going to get?
Yes, sir.
My
Leaving aside those things.
Yes.
That this court will look into that.
Yes.
Yeah. But this court can very well give this particular under 108, no?
Yes, Lordship, 108. Because now they have also filed a affidavit enclosing a missing report, Lordship, from police, Lordship. Therefore, otherwise, maybe there is a
Where's the presumption?
It is under 108, man.
108 is burden.
That is, there's no other provision, man. 107 and 8. 108 is like provision. I've got two judgments, one judgment.
Heard Mr. A.K. Maheshwari, the learned counsel appearing on behalf of the petitioner.
Well,
Mr.
Arrear,
K.
man.
Kolita appears on behalf of the respondent, Oil India Limited. Pursuant to the petitioner has filed an affidavit on 16/2/2023, enclosing therewith a GD entry as well as the enclosing therewith a police report to the effect in respect to GD entry number 154 dated 9/4/2015 about missing of the petitioner's husband since 5/4/2015. It has been further mentioned in the inquiry report that during the inquiry made, nothing could be found out. The husband of the petitioner could not be traced out. Taking into account the above, and as 7 years expires on 9/4/2022. 9/4 or 9/5?
He was missing since
9/4/2022. The learned counsel appearing on behalf of the Oil India Limited is directed to apprise this court on the next date as to what benefits the petitioner would be entitled to in terms with the Oil India
Superannuation Benefit Pension Scheme.
Superannuation benefit super
All India Superannuation Pension Benefit Scheme.
benefit scheme. List the matter again on 5th of June. Yes.
On last occasion, I was instructed to get some instructions, but the instructions were not proper because your lordship specifically inquired whether review had undertaken. I inquired, but they just they didn't answer this particular query.
Yes. You have submitted the reply.
Yes, I submitted my reply on 12/7/2020. Annexer
20?
12/7/2022. Annexer 6.
Now, how long?
That's what your lordship, I've been told telephonically that review as such has not been undertaken. But since no written instructions have come forth, I have asked for written instructions to that effect that review has not undertaken. Also, with regards to DP, since there is a police case pending, all those documents has been seized by the investigating officer, and that has not yet been released. So that's why the DP is stuck.
Petitioner was placed under team suspension, your lord. And there is an office memorandum guiding how the proceeding has to be done and the prescribing the period, your lord.
Which one? 4/2/2020.
Yes, your lord.
What is the allegation against the petitioner?
There was nothing in the FIR, your lord. I was not named in the FIR, your lordship. There was a conspiracy of forging a sale deed, your lordship. And I am working as a office peon in the court.
Office peon only does all this thing.
But manipulation cannot be done, your lordship.
Very easy. They are the main person.
Manipulation. Your lordship, the show
Mr. Counsel, you must be knowing. A file or a seal deed would not come to that officer's place unless it is done through the peon.
Yes, that I
Page
agree, your
49.
lordship.
your lord. Page
Only
49.
with regard to the processing of file, your lordship. But manipulation
Where is the
cannot
FIR?
be carried out.
Your lordship, FIR is not annexed. Page for 19. your lordship.
19 is the SOCO.
Show cause Annexure 5,
In fact,
5th July 2022.
it is, it cannot be termed as a memorandum of charge or charge sheet, your lordship. Allegation was that if there was a conspiracy made by one Sri Papa Mojumdar, complaint by Papa Mojumdar, had a criminal conspiracy amongst themselves. And I have made a categorical statement. I have not been named in the affair.
What are you asking in your show cause?
Show cause,
This is not a show cause in terms with that.
this is
Not
not a
even
show
going
cause.
for review.
No, what are you going to decide? Tell me.
They, in fact, after this show cause, after the reply, I've been that in that instruction, they have appointed inquiry officer, also the presiding officer also. But
Understood, but do you have appointed the inquiry and presiding officer prior to that?
prior to that,
That you have exercised 9/4 before 9/2.
And no review of this suspension.
let me get the written instructions. Your lordship may fix anytime next week. If your lordship fixes on Wednesday, I'll get the written instruction that no review has actually undertaken. I've been told telephonically, but
Almost more than about 1.5 years, your lord.
Understood, but on the last occasion you were not appearing. Then also this court passed this order. Anyways, your name?
I am armed.
Huh?
Armed.
And so the learned counsel appears on behalf of the petitioner. Mr. D. Bora appears on behalf of the respondent number 2. The instant writ petition has been filed challenging the order of suspension dated 11, challenging the action of the respondent authorities in the continuation of the suspension of the petitioner on the basis of an order of suspension dated 11/2/2022. To the said petition, the show cause notice, which the respondent authorities claims to be the memorandum of charge of the charge sheet, have been enclosed as Annexure 5. However, it is relevant to take note of that the said show cause notice does not contain any definitive charge or any statement of allegation against the petitioner. Be that as it may, even prior to the petitioner submitting the statement of defense, the inquiring officer as well as the presenting officer was appointed on 5/7/2022. Thereafter, the petitioner submitted the statement of defense on 12/7/2022. This court, on an early, by the order dated 23/2023, inquired with the learned counsel appearing for the respondent number 2 as to whether any review has been done pursuant to the submission of the memorandum of charge, which is otherwise the mandate of the Supreme Court in the case of Ajoy Chaudhary versus Union of India, reported in so and so. The said instructions, however, is forthcoming. However, is not available. This court, taking note of clause 2.18 of the manual regarding departmental proceedings, from FR 53 of the FR&SR as applicable to the state of Assam, as well as the office memorandum issued by the Chief Secretary to the government of Assam, dated 4/2/2020. Six, the instructions from this court, from the learned counsel appearing for the respondent number 2. Six, the instructions directs the respondent number 2 to apprise this court as to whether any review was carried out pursuant to the issuance of the memorandum of charge, public the charge sheet, enclosed as pursuant to the show cause of notice dated 5/7/2022. It may also be relevant at this stage to mention that the said show cause notice is also vague as to what penalties which the disciplinary authority proposes to impose. Be that as it may, this court fixes this matter again on 26th of May 2023. So that the respondent number 2 can apprise this court on the next date. in respect to the queries.
Oblige, your lordship.
36.
May,
Yes,
as per last order, my lord, they are supposed to file the affidavit or they haven't filed. And on the other hand, my lord, the law office and district office, they are giving pressure upon the petitioner to sign the pension paper prior to fixing the date of his last joining instead of his date of retirement.
what is your case?
My case is, my lord, the petitioner.
Yes, what happened, Mr.? You
Lordship,
were supposed to get your instructions.
Lordship, we received a parawise comment, Lordship. As per my instruction, Lordship, the petitioner did not join. He did not join from the date of his transfer. Even prior to that, he was absent, Lordship. This is in fact the fourth round of litigation, Lordship.
Huh?
This is fourth round of litigation on the same subject matter, Lordship. Lordship may kindly peruse the order.
No, it's okay. As regards area salary, we'll assume that.
Lordship.
But what about the other benefits?
Other benefits, Lordship, the provisional pension he is getting, Lordship.
Ah.
And perhaps we need to
So
file it.
then I think when you are refuting to this, you file your affidavit.
Lordship, we need to file our affidavit, Lordship.
Not Mr. B requested the learned counsel appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the Elementary Education Department. Mr. P. N. Sharma submits upon instructions that there are serious disputes as regards the entitlement of the petitioner, for which the department would like to file an affidavit. He further submits that at present the petitioner is receiving his provisional pension. However, as the petitioner have not received the other pensionary benefits, this court deems it proper that the matter needs an early disposal. Accordingly, this court fixes this matter again on 28th of June 2023. The Elementary Education Department shall file their affidavit without fail by 23rd of June 2023.
37.
Yes, your lordship. The application shall direct to the finance department.
Yes, Mr. Voluntary. Why you are not giving it to him, the minimum scale of pay?
The difficulty is there, my lord, that it was a one-time exercise. The petitioner's name, my lord, that was sent in an additional list. And this is happening, my lord, with only with regard to three departments. PNRD department, Hill Areas department, and Irrigation department. Time and again they are, my lord, sending. So therefore, we are issuing instruction that you check it, check the proposal and resubmit again. Verify if ineligible persons are listed, because we have to also deal with the exchequer. And lordship will find almost 13,800 in the second page of the bunch of papers. Second page, yes. This is the, my lord, intra-office, my lord, communication in the finance department. They are in the last paragraph, lordship will find. It may be stated that final decision has not yet been taken for extending the benefit of minimum pay scale to additional pending list of different departments, including PNRD department. It is pertinent to mention that in pursuance of Honorable Guwahati High Court's order dated so and so, Finance Department has approved the total limit of 13,821. So 13,821 we have already approved. Now I am told, my lord, that this committee, it is not sitting as of now, but it will sit very soon.
But whatever may be, there is an order passed by the division bench You have no way out unless you go for a clarification with the order of the division bench saying that, look here, we have already done 13,821, enough of enough. We don't want to do any further. We don't mind contempt proceedings being initiated against us, but we are not going to do it. Sorry. Do it. That you are not doing it. You are making the submission before a single judge.
Lordship may dispose of the application directing the finance department to take a call within a definite time limit with regard to the petitioner.
What is there to take a call? There is no taking a call. There is a direction that
Yes,
he is
yes,
entitled to.
direction, yes.
He's entitled to. Where is the taking a call for that? The taking a call is a different aspect of the matter. You may go to some other court.
Otherwise, Lordship may
You want to
post
go
it.
to some other court to get this type of orders?
Lordship may be pleased otherwise, my lord, to take up this matter after at least 2-3 weeks. In the meantime, development takes place, I can apprise. Otherwise, Lordship may be.
Lordship, on 27th, the Lordship observed matter and the Panchayat Department specifically states that the petitioner is entitled, Lordship. In this order, Lordship.
No, there's no quarrel. Your name was sent in an additional list number 5, if I remember correctly, isn't it?
Yes.
Yeah, list number 5. Now they are saying this additional keeps on sending this list of 5, but they can't help it. They can't help it. Because your departments have done this. Your department, your finance department has no problem in paying people's salaries who have not even got their appointments out there properly. Then also the finance department has no problem, but in complying with the orders passed by this court, you have problem. What to do? Yesterday, I was taking the whole lot of matters pertaining to the health department. They say, and the basic case of the petitioner is, look here. Everything, let us assume that finance SIU approval was not taken. But why the finance was releasing our salaries for the last 15 years? There you have a problem. You have no problem. But you have a problem when the additional list is given by them.
I am told, my lord, that with regard
You have
to
a
this-
stepmotherly treatment towards the PNR, but not with the health.
Not as such, my lord.
It is.
No, if
Health has no problems with the finance. Although there is one matter going on. Maybe the principal secretary happens to be the same all along, keeps on interchanging out there.
I may not comment.
Then that must be the reason. Otherwise, you have in all other matters, you have a problem with the PNRD. I don't know, my irrigation matters doesn't come much before this
No,
court.
because my instructions specifically state, my lord, the 7 except these 3 departments, my lord. These are the 3 departments which are one.
Which is always a loggerheads with the finance. Huh? They always support the case of the petitioners, and then the finance creates the problem. Look at that, the matter of Mr. Orup Borbora. There also, you are creating the problem. We fix it in the month of July. Do something.
No, before July also, my lord.
No, I'll fix it on 21st of July. They should get it in the meantime.
21st.
I don't want to dispose of so that later on file contempts these matters. Do something in the meantime, because you cannot say that unless you seek a modification of the
Yes,
order,
correct.
you cannot say
Yes,
anything.
yes.
Because the order is specific. Anybody who has done this 10 years, you have to make that exercise. Now, if the department has made that mistake in sending 10 lists or 15 lists, the petitioners can't be put at blame if they come within the ambit.
No, absolutely. Absolutely.
Heard, Mr. AMS Mujumdar, the learned counsel for the petitioner. Mr. Your name?
P. Hendrik.
P. Hendrik appears on behalf of the Panchayat and Rural Development Department. Mr. R. Boputari appears on behalf of the Finance Department. How many petitioners?
One.
Lord.
I am safe.
The case of the petitioners herein is that the petitioner is entitled to the benefits of the judgment passed by the division bench of this court in the case of the state of Assam versus Upenda in writ appeal number 45/2014. In fact, from a perusal of the orders passed by this court, and more particularly, the documents kept on record as with a letter and with the letter marked as an X, it appears that the petitioner's name was also forwarded by the Panchayat and Rural Development Department. After due verification that the petitioner is entitled to the minimum of the scale of pay as directed by the division bench in the judgment in the division bench in the case of Upenda Supra. Today, Mr. R. Bapuja, the Learning Council, appearing on behalf of the Finance Department, submits that in pursuance to the judgment of the division bench in the case of Upenda, the Finance Department have already approved the total 13821 numbers of workers for payment of the minimum of the scale of pay. However, on account of the submission of the additional list by 3 departments, that is the PNRD departments, Hill Areas Department, and Irrigation Department, over and above the original list, there has been, it has resulted in problems. It has resulted in difficulties faced by the Finance Department. And as such, no final decision has yet been taken for extending the benefit of minimum of the pay scale to additional pending list of different departments, including the PNRD department. This court, upon hearing the Learned Council, finds it relevant to take note of paragraph number 22 of the judgment of the division bench in the case of Upendas. Where is it? Upendas. Why is that Upendas judgment not reported?
Reported.
Every
Yeah,
time.
it is reported.
Upendas. Wherein there is a specific direction to the state government to pay the minimum of the pay scale to master role workers, work charge workers, and similarly placed workers working since the last more than 10 years, bracket, not in sanctioned post, bracket close, with effect from 1/8/2017. Paragraph 22 of the said judgment being relevant is reproduced hereunder. In view of the above directions so passed by the division bench of this court in the case of Upenda Supra, this court finds that there is no liberty given to the finance department not to grant the benefits to the minimum of the scale of pay to those persons who are covered within the ambit of paragraph number 22 of the said judgment. It further appears that the Panchayat and Rural Development Department, while sending the details of the petitioner along with others,
List 5, serial number 110.
paid
List 5,
serial number
110.
have categorically mentioned that the date of engagement of the petitioner was on 28/2005 and his length of service till 2007 was 12 years. Under such circumstances, this court therefore gives another chance to the finance department to do the needful in terms with paragraph number 22 of the said judgment in the case of Upenda Supra. Insofar as the petitioner is concerned, accordingly, let the matter be listed again on 21st of July 2022-23 for instructions.
On that date, I may be allowed to upgrade
What?
for upgrade, mention for upgrade.
I've said instructions. See, instruction.
Yes.
It will come.
Obla.
My lord, this Upenda says, my lord may note it, my lord.
Hey, I've got it 2025 as GLT 605.
605, yes.
To provide you a 38.
Obla.
Now I'm keeping it here.
My lord. So obliged.
Yes.
My lord, petitioner retired as a general.
Oh, did you get your instructions?
In fact, my lord, in fact, there are two similar matters. Two incumbents retired on the same day. And my lord, there is a judgment of a coordinate bench. We say that both the matters are covered by that coordinate bench judgment. My lord, yesterday the matter was disposed of in the line of the article.
Who?
Court number 5.
You want to go to court number 5?
No, no.
I've asked you to obtain the instruction as,
Yes, yes,
as to whether the judgment is squarely covered.
Yes.
That is what I have asked the instruction for that. Because the issue is, which have been decided by the coordinate bench, is that this court is that the person cannot be treated to have retired on 31/3/2016 and it is only on 1/4/2016. He would be deemed to have retired and accordingly he will be entitled to the benefit in terms with the 2007.
My instruction that there is a need.
Yes, what do you say?
They preferred and readable, my lord, in the earlier case, my lord. In readable, the interim order was rejected, but there is a rider, my lord. That your lordship kindly that
Will
create
be
problem, my
limited
lord.
to the case of the respondent. So you shall reimburse the excess.
In the event the writ appeal is allowed, that is, my lord, the order I have annexed the writ appeal order, but you will kindly come to page 64 of the.
Page?
64. This is the coordinate based judgment was taken to appeal by the APTC.
That only, ma. While accepting the service, which is
So we are claiming similar relief as directed by the learned single judge on 3/11/2020.
and you are willing to give that undertaking. Heard Mr. J. Patwai, the learned counsel appearing on behalf of the petitioner. Mr. S. Kutuki, the learned counsel appears on behalf of the respondent number 125. This court, by the order dated 10/5/2023, sought the instruction from the learned counsel appearing on behalf of the respondent number 125 as to whether the judgment dated 3/11/2022 passed by a coordinate bench of this court in WPC number 1607/2022 would cover the issue involved in the instant proceedings. The learned counsel appearing for the respondent number 125 submitted that although the issue is covered by the judgment dated 3/11/2022 in WPC number 1607/2022. 22.
Judgment is 22, WPC is of
20.
1607 of 20. 3/11/22 passed in WPC 1607 of 20. Page 65, madam. Last page.
But 1607 of 20. But the respondent numbers 1 to 5 herein have already preferred an appeal.
Not my, our sister company, appeal.
Appeal by the
But against the said judgment and order dated 3/11/2022, an appeal has been preferred before the division bench in writ appeal number 107/2023. The learned counsel for the respondent had submitted that in the said appeal, although the judgment and order dated 3/11/2022 passed in WPC number 1607/2020 have not been stayed. However, it was observed that the respondent in the writ appeal, that is oblique, the writ petitioner in WPC number 1607/2020 shall give an undertaking to the effect that in case of the success of the, in case the appeal is allowed, the respondent therein shall reimburse the excess amount, if any, paid to him on account of the order, judgment and order dated 16/11/2020. 3/11/2022. The learned counsel appearing on behalf of the petitioner submits that the petitioner is also willing to give a similar undertaking to that effect. Having heard the learned counsels for the parties And taking into consideration that the issue involved in the instant writ petition is squarely covered by the judgment dated 3/11/2022 passed in WPC number 1607/2020.
Annexure Z here, it's page 50.
This court disposes of the instant writ petition. That as the petitioner herein have had attained the age of superannuation on 31/3/2016 cannot be categorized and bracketed in the category of existing pensioner on 31/3/2016, as he acquired the status of the pensioner only on and from 1/4/2016. Under such circumstances, the petitioner would be entitled to the benefit under the revised pay rules 2017. Now, under such circumstances, the petitioner would be entitled under such the entitlement of the petitioner has to be worked out in terms with the provisions laid down in Rule 4 bracket A folly of the revised pay rules 2017. Accordingly, this court therefore directs the respondent authorities to work out the entitlement of the petitioner as pensioner under different heads like pension, commuted value of pension, bracket CVP, bracket close, death cum retirement gratuity, leave encashment benefits, etc. If after such exercise, the petitioner is found entitled for an enhanced amount, that what has been worked out where worked out where?
I left on 2016 as I was in service.
Worked out in this one, 19/4/2016. This one, nah? So this has to be worked out. 19/4 and page 28.
At page 15 and my lord page
28.
My lord, page 15 and 17 I have given the chart.
What is that, page 15 and 17? I'm not on those.
So what has been given and what I am entitled?
I'm not on those. I'm saying about page 28.
Heads are there on page 28.
Yes, we are only concerned with this.
Yes, this has
Then
been given.
why you are not coming to the point? The petitioner is found entitled for an enhanced amount than that what has been worked out in the office order number AEZCL/ACT/PEN/11808/16/220/2 dated 19/4/2016. The same should be disbursed to the petitioner in an expeditious manner. It is further directed that the said exercise be undertaken and completed within a period of 2 months from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number 2. Next. Before parting with the record, this court further deems it proper to observe and direct that the petitioner shall submit along with the certified copy of the instant order an undertaking to the effect that in case the writ appeal number 107/2023 is decided in favor of the appellant therein, he shall reimburse the excess amount, if any, paid to him on account of the if any, paid to him on account of the order passed herein.
Deeply.
39.
May it please your lordship.
Yes,
Last
madam.
occasion, lordship has directed me to take the instruction. I have received instruction, my lord. No review till date, my lord. And charge memo has been served on 11/5/2023.
11/5,
2023, my lord.
you have given?
2022.
Charge memo given?
My lord.
Okay.
Yellow flag. Yellow flag.
Okay, you charge memo to you have given. So you got your charge memo?
I did not receive. Suspended 5/11/2022.
And they have issued it. You will get it. You want the
No
copy?
copies are
You want a copy of it?
lordship.
So charge memo is being given. You make a review.
My lord.
Sport of the petition.
My lord.
I can't touch the suspension order.
Because whether they are reviewed or not. Question is that 5/11/2022.
They are to review it. They will review it. They have only given on 11/5. How many days have gone? We are 19.
I have been
Review
suspended
it
5/11/2022.
by 23rd.
My lord.
My case is I have been suspended on 5/11/2022.
Understood, but third memo have
Still-
been already issued. Have you issued or not?
My lord is so.
When?
When they
It is within 11/5/2023. The yellow flag, my lord.
No, that I've seen
11.
it, but have you issued or is it in your pocket?
No, already so.
When? Has been served against the Iman, against the officer by number so and so dated Iman enclosed. Have you served or not?
I have been told that it has been served, my lord.
Huh?
I'm not aware whether the person has received or not, but it has been served.
Smita Kakoti so and so to eligible Iman regarding fraudulent issue of driving license by Rajiv Chandra. Enforcement inspector. Chalo.
My lord.
My submission is that within 90 days, as per law settled, as per Ajay Kumar Choudhury, it has been submitted, reviewed, or within 90 days. That is the law. But it has
If
been
you
5/11.
kindly tell you.
Recently,
This matter, Ajay Chaudhary with words, letters, alphabets,
I know.
this court have been
Any
taking.
reason, things,
Yes,
but
my lord.
And every time I'm repeating paragraph 22, paragraph
Yes,
22,
Lord.
paragraph. So under such circumstances, once the charge sheet has been given to you, nothing.
when they reviewed or when submitted, that is with the period not.
Hmm?
Within 90 days, they have done it.
Yes, Mr. Dhar, you are smiling out there. One thing, that matter, na?
Yes,
Sushant Dutta matter. In that matter, the trial is started. Criminal trial must have started.
I have to seek information.
No, it must have started because the charge sheet was given long time back,
Long time back.
2021
Yes,
and
ma'am.
20. The charge of, after all, maybe the trial, it is already there. Some case must be there.
Yes, case must be.
Just let me know.
I will just.
I'm almost ready with my judgment. I have to just deliver it. Only that thing I wanted to know, or I have to then, I can find it out by going into the all these things. You know. Just,
I
you
will
can
call up
just find
the-
out.
I will call up the
Just find out
CIDO.
where it is there. No, I can't help you.
Submission and the submission, let them to file an affidavit against it.
Lordship may grant me 2 minutes time. I'll take a telephonic instruction whether this has been served to the petitioner or not.
Fantastic.
And
2 minutes.
Just.
My submission is
Now,
that.
Mr. Borgonia, I am here.
agree with
I am here till 5 o'clock. Don't worry. I'm
My
coming.
submission is
My lord,
that.
I'm
Lordship-
getting
Let
the
me
instruction.
just
My sub-
take up the next matter.
My lord,
I'll take up the matter after, then I'll take up your
My
matter.
lord.
Okay.
Obliged,
Mr.
my lord.
Lordship, permit this small word. Lordship, I am submitting, let them to file an affidavit regarding when they have filed, I will file a return. Just by
Let them get him
Lord-
first,
Lordship,
then I
yes,
will
yes,
see.
Yes, got it.
Oh.
Obliged.
49. Yes.
Your Lordship, this instant writ petition is for the inclusion of the name of the wife, the petitioner, in the service records of the private respondent, respondent number 4.
Yes, what has happened as regard the service?
Steps were taken upon respondent number 4, but
Okay, so is that the petitioner is the sole wife of the respondent number 4. The petitioner married to respondent on demand. However, in spite of submitting a return, they have not included her name as one of the nominees. Yes. Why haven't you done that?
Lordship, respondent number 4 is necessary. Lordship, we have a limited role here, Lordship, because the inclusion of the name of the wife depends upon the respondent number 4, Lordship. You will include the name. We cannot force it.
Does he have an option? Now, there is a very relevant question because that day I was taking up one matter when Madam Bora was there. The father included the name of the son and not his wife. By the time the father died, the son became 37 years old. So he's not entitled. But his wife is still there.
That is not.
Is it permissible?
No.
Then if it is not permissible, why not here? Can a person choose whom to nominate? Or is it on the basis of what is given out there in the rules?
It's based on the basis of what is given on the rules.
So does the rules provide a scope of nomination? The horse, what is mentioned in the rules, because the rules categorically mention what is it. Yes, Mr. Gogoi.
Nothing, but my colleague was there. I had a submission. I was going through the file, I found, this petition is already retired. He has severe ties with us, my lord.
Huh?
He has severe ties with us, my lord, because he's already retired. So in that situation, if he doesn't include anybody's name, that is not within our purview now.
Whose purview?
Department's purview, my lord.
Whose purview? You tell me. Somebody has to
be there. The pension rules I have to go through, but otherwise,
no, it is not required. But let me tell you, who will send a proposal to the director of pension?
It is a department. But my lord, now
so till he does not get his pension, if he is getting his pension, therefore the specific question is, does the person, the respondent number 4, have a say that I will not include him or her? Or is it good to go as per the rules?
That point has to be looked into, my lord, because it is his service, his own service book, it is his nomination. Everything falls under him, my lord. Apart from if he is entitled, we are not claiming, we don't dispute anything. But my only anxiety is, my lord, since he is retired, he has severe ties with us, my lord.
No, he's not segregated his ties, because if anything has to be done,
my lord,
can a person say, look here, I don't want my family pension? Can he relinquish his family pension?
No.
Because it is not his. He will take his pension all along, but he says that I don't want anybody. Can he say that?
Quite a question, man. I have to.
Because isn't it a very important issue? Because this issue that day arose, as I was telling a colleague out here, the father nominated the son, but did not nominate his wife. By the time the father died, the son became 37 years old. So obviously, but the wife was ill there. Now, wife has come up before this court asking for pension. Then look here, I am entitled to, as per the rules. So therefore, the question arises as to can a person say anything that I'm not entitled to? I'm giving up no family pension.
But in one case, if I can recall correctly, a person was his pension papers returned because nomination form was empty. He didn't nominate anyone. In the course of the proceedings, my lord, it was enlightened me upon me that the court had honorable court had my lord, kind of impression that if a person doesn't want to nominate, you cannot return back his papers. Or like if he doesn't want to nominate, it is up to him. So that person is my lord, is enjoying his pension right now.
Now, if he doesn't nominate, what happens to the family?
That has to be
because
looked
the
into.
right to get the family pension is upon that person, his husband or whoever it is, the pensioner, completing a particular qualifying service as well as also having 1 year of regular service. Okay. Now, if that is so, wouldn't the right accrue under 143?
That has to be, my lord. Is a though, my lord. And apart from that, my lord, other anxiety, my lord, since that nomination is a part of the service book, my lord. After retirement, can the service book be altered now?
It is not the service book. You are not going to change the service book. You are going to do one thing. You are going to send a proposal to the Director of Pension or the Accountant General who shall make necessary entry in the pay order, pension PPO. That is what it is to go. Then where the nomination has to do with the service book? Service book, I have all this while I have never seen a nomination of the pension. Then
and my lord, this
Mr. Counsel, have you taken service upon the respondent number 4 by way of you have taken it by way of notice have been issued on 26/4. Service is not there. Without the respondent number 4, you can't help it unless you take dusty service. I can't help you.
Service usual process, we took by usual process and registered both, but they did not.
You service by way of dusty because if you want an early disposal, if you not, no problem, we have to await for the service because the problem is with the respondent number 4. Now, once the respondent number 4 is there, this court can impress upon him to do that if it is, unless he is so estranged with you.
Yes, so by way of dusty, we might take the service. Good.
Heard Mr. M. Islam, the learned counsel for the petitioner, Mr. D. Gogoi, appears on behalf of the respondent number 1, 2, and 3, and Mr. D. Bora appears for the respondent number 2. The records does not show that the service upon the respondent number 4 is complete. For the purpose of deciding the instant matter, service upon the respondent number 4 is a must. Accordingly, the learned counsel appearing on behalf of the petitioner, though submits that steps have been already taken by way of this registered as well as usual, the petitioner is further willing to take steps by way of dusty. Accordingly, the petitioner is directed to take steps by way of dusty, routed through the registry of this court, and file an affidavit of service on or before the next date. List the matter again on 21st of June. Mr. Gogoi, you look into and find out. Very important question.
Timing item 39.
My lord, I have received the instruction, my lord. The same day, the charge may was served to the person in his personal mail.
No, Lordship, here is the case. I have been suspended on 5/11/2020. My learned friend said now they have submitted charge. But law is settled that within a period of 90 days, that suspension order has to be reviewed or charge has to be submitted. But in the state case, within that period, they have not been submitted. If required, to file an affidavit, I will count out.
File an affidavit. I am not going to touch anything.
But law is very much settled. May I read one paragraph, Lordship?
Of
by referring the judge of this Kumar, this honorable court's judgment, Lordship. In the report in 2019 Board NEJ 1944. Atpur Rahman versus State of Assam, paragraph 99. Made it. Having considered the provisions of the Assam Services Discipline and Appeal Rules 1964, read with the manual referred to above, and the various decisions of this court, as well as the Honorable Supreme Court, more particularly the decisions in Ajoy Kumar Chaudhary Supra, and for the reasons discussed above, this court would hold that even in case of deemed suspension under Rule 6.2 of the Assam Services Discipline and Appeal Rules 1964, where charge sheet in connection with a criminal case has not been submitted before the competent court within 3 months, the disciplinary authorities would be required to review for continuance of suspension by seeking advice of the Departmental personnel in the same manner as provided under para 2.1.8 of manual. As a consequence, if such review is not held within 3 months, where charge sheet is not filed before the competent court, the suspended employee would be entitled to be reinstated in service. The employees deemed suspended under Rule 6.2 would be entitled to similar treatment extend to the employees suspended under Rule 6.1 of the Assam Services Discipline and Appeal Rules 96. I am on their side. They have not reviewed within 90. Now they have been submitted. It has to be within 90 days.
Ajoy Kumar Chaudhary, does it say when the review has to be done?
Yes, even review can be done, but reasoned order to be passed. It has
The
to be
review will
reasoned,
be done.
continuation suspension.
If you see the Ajoy Kumar Chaudhary, what does it say? See paragraph 21.
Yes, sir. Paragraph 21. We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension. As in the case in hand, the government is free to transfer the person concerned.
That is not required. But
That is not required.
the reason order has to be passed when?
A reason
When?
that my understanding within 90 days, but the moment whether the continuation order is passed or not, reason. The state that
See paragraph 22.
so far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, and therefore this direction may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continuous suspension in any manner known to law, and this action of the suspended will be subject to judicial review. So my learned friend will direct to file an affidavit. I will counter.
This is what I say. Heard Mr. F.P. Barbhuya, the learned counsel, appearing on behalf of the petitioner. Ms. M.D. Bora appears on behalf of the respondent number 1, 2, 3, and 5. Mr. D. Bora appears for the respondent number 4. This court, by an order dated 12/5/2023, sought the instructions from the respondent authorities as to whether the memorandum of charge and all the charge sheet have been served upon the petitioner, and as to whether there has been compliance to the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India, reported in 2015, 7 6291. The learned counsel, appearing on behalf of the respondent number 1, 2, 3, and 5, submitted that the statement that the memorandum of charge was served upon the petitioner on 11/5/2023, when the same was issued. As regards the question of review, the learned counsel for the respondent further submitted that the department is in the process of taking the due action, necessary action in terms with the judgment as regards the review to be made in terms with the judgment in the case of Ajoy Kumar Chaudhary, as well as the office memorandum dated 4/2/2020 issued by the Chief Secretary to the Government of Assam. The learning council for the petition, the how much time?
Let's say 2 weeks, my lord.
The learning council for the petitioner insists that the department should file an affidavit in that regard. Taking into account the same, the department is directed to file the affidavit by 9th of June.
My lord.
List the matter again on 12th of June.
Lordship, liberty may be granted to us to review the order, my lord, because
That I've already mentioned
my
that you are in the process. I have
My
not
lord.
said anything.
My lord,
Why
my
should
lord.
I give?
My lord, I am deeply obliged, my
The
lord.
learned counsel appearing on behalf of the transport department has placed on record certain documents which are kept on record and marked with the letterheads.
I am deeply obliged, my lord.
50.
Obliged.
Regarding the Prati plus
Oh, when should I fix that?
29th, my lord.
Please the matter on 29/5/2023 along with WBC number
56, 36, 16.
5636.
56, 36, 16, my lord. It seems that, my lord, the real respondents are not very interested in this case.
Huh?
The real respondents who have the burden, my lord, they are not very interested. They have left everything on me.
No, that is why I told it to the managing director. I can't say something more than that.
Exactly, my lord.
Okay. 29/5.
At number 21 and 22, order stay vacating.
You are getting episodized. What are these matters for stay vacating? Why?
My lord, a matter relates to my lord, a seniority of two teachers, my lord, of Rajgarh Girls High School. My lord.
Huh?
The matter relates to seniority, my lord, of two teachers of Rajgarh Girls High School. My lord.
There is a stay vacating application.
And my lord, the order is Lord Philip and it pays 65, my lord.
Page
65 and operating portion is at page 66.
65. I is bigger than the year.
IA 507 of 2023.
28, 26/8/2022.
5/8/2022, my lord.
Huh?
66.
5/8.
Page 66 of the IA, my lord.
Understood. Where is that order?
Page 66.
No, that is there, but where is the main order? Which order you are asking for vacating?
At page 66, my lord.
In the writ petition 5563.
5032 of 2022.
5032. Yes.
At page 65 and operating
The order dated so and so issued by the Secondary Education Department shall remain stayed insofar as the writ petitioner is concerned till the next day. Let us see that order.
That order also will find at page 59.
50?
59.
69.
59. And It was passed, my lord, pursuant to the order passed by this honorable court.
5-9 of where? Of your application?
Of my IMI.
No, no, which order? The petition, where is that, Mr. Borua?
Petition, my lord, will find that.
Which order? Where have you
Case
obtained the stay?
74, my lord.
Huh?
74 at which petition, my lord.
24. What is this order? Peruse the High Court's order dated so and so, filed by Kalyani Chaudhary.
I am Kalyani.
Versus, huh? You are Kalyani Chaudhary?
Yes,
Versus so and so. Okay. Then what is the matter? The requirement to be done within 50. What is the finding? It is here we are consciously not providing for any hearing of the headmistress of so and so from the point of view that it is the direction to the director to make necessary correction in the service book of the petitioner based on the records of her service, and merely because the headmistress may increase the service of the petitioner does not mean that the headmistress have any vested right in such, and we require opportunity of hearing directly. Requirement to be done.
He wanted modification, an interim order. That order is only for purpose of my. There is some adverse remark given against me. That was stated by this court. Others are not touched on the interim order, which they come to some. Because it is the case from third down litigation. Earlier, writ petition has been decided. Writ appeal has been
Where is
made.
the adverse remark? Where is the adverse remark in the impugned order?
Yes, Lordship will find
Page 75.
page 75,
Matter of Srimati Mansoor.
last part.
Was
bold
originally
one.
appointed as senior head teacher of so and so in the scale of so and so. In the subsequent period, in person was promoted to. Yeah, where is the adverse? The appointment there was
Yes,
extended
Lordship.
until further orders by the inspector of school and on later in person to this order occurred due to retirement of so and so in the scale of. Was originally assistant teacher. So you have challenged this portion.
Yes.
At page 75, the lower portion.
Yes, because it
Which had nothing to do with her.
nothing to do with him.
Lord, my lord, due to this interim order,
And
my
in
lord,
fact,
Yes.
due to this interim order, my lord, my service book has not been updated.
Okay. So we clarify.
Yes, my lord. That
is Overstay
No,
on
no,
that part.
we clarified that.
yes, my lord.
We clarified that this IA has been filed for that, and the difficulty faced by him is because of the misapprehension that the order has been stayed.
Hmm.
The authorities are not correcting the service book.
Yes, my lord.
So we say that this order will remain. However, without, and the same shall not be an embargo on the part of the authorities to act in terms with that order of 26, 2022.
And for that,
without affecting the.
yes, for that, this is the judicial position. They have filed another writ petition. Only for that that occasion, that is 5556.
In the
same issue.
In the days of COVID,
Yes,
in the days where litigations are less, somebody may like to do. Can you stop it? So we clarified that. Matter in. And he wants this. Kalyani Chaudhary, why have you filed a petition for not giving it?
Yes, my lord, for not affecting that order, my lord. Not to give an effect to that order, my lord. That impugn in the writ petition, my lord. Where it has been recorded, my lord, there is no material available regarding my service break, my lord.
And this has been done by the Director of Secondary
Director
Education.
of Secondary Education, my lord.
Yes, madam.
Page 76, my lord. Principal and headmistress was directed to make necessary corrections.
You are not following your own order.
Because I had a copy. Because that is.
You are the main person. Kindly come here. We still have a glass. Next week you may not. I'm trying my best to get it done. Remove. Yes, madam.
Lordship, because there is a stay of this order, that's why they are not.
That is why I
proceeding.
clarify it.
Lordship, Lordship.
Once it is clarified, you will do the needful in the other. So your eye is disposed, this will dispose. Okay. And he is happy with his matter. Isn't it?
Well, without affecting my other rights, only that the order.
I'm Mr. Bolu, I'm passing the order in your presence. I'm not putting it as CAB. No, you listen. No, you listen to that. No, Mr. Borua,
Yes.
let me pass the order, then you will see. But Mr. Your name RM Deka.
Yes, ma'am.
The learned counsel appearing on behalf of the applicant. You are a party in the proceeding? No. In the writ?
In the writ, I am respondent number 5, my lord.
Why have you made him a party?
No,
that is the problem. Why have you made him a party? All the situation arose because of that. You are aggrieved by what has been given out there in so far as your case is concerned.
Yeah.
Nothing to do with him. You are making him a party. Appears on behalf of the applicant, the respondent number 5 in the writ petition. Mr. P.P. Bolwa appears on behalf of the writ petitioner. Ms. D. Mutari, the learned counsel, appears on behalf of the Secondary Education Department. The instant interlocutory application has been filed seeking modification and clarification of the order dated 5/8/2022 passed by this court. It appears from a perusal of the interlocutory application that pursuant to orders passed by this court in WPC number 44, pursuant to the order passed by this court in order dated 17/9/2021 passed by this court in WPC number 4486/2021. As well as the order of the division bench dated 5/3/2021 in writ appeal number 278/2017. The Director of Secondary Education had passed an order on 26/2022. In the said order, the Director of Secondary Education after hearing the officials on 15/2/2022, made certain observations in respect to the case of the applicant as well as also the case of the writ petitioner. Insofar as the case of the applicant, that is Srimati Kalyani Chaudhary, The Director of Secondary Education observed that the applicant, Srimati Kalyani Chaudhary, was originally appointed as a senior Hindi teacher of Rajgarh High School in the scale of pay of rupees 1375-3375 per month plus other allowances as admissible as per the rules for a period of 3 months, while the order dated 3/3/1994. Thereupon, the terms of appointment of the applicant was extended until further orders by the then Inspector of Schools, KDC Guwahati, by the order dated 10/3/1995. Later on, in pursuance to the government's letter dated 17/3/2001, the applicant was adjusted at Rajgarh High School against the post of Hindi teacher occurred due to the retirement of Srimati Labanya Talukdar, Hindi teacher, on 31/3/2000 in the scale of pay of rupees 3,580-8750 per month, and other allowances as admissible with effect from 1/4/2000 by office order dated 21/3/2001. It has also observed that in the subsequent period, in pursuance to the government's approval on the recommendation of the State Selection Board, communicated by the government letter dated 11/12/2010, the applicant was promoted to the post of Assistant Headmistress of Rajgarh High School under Kamrup Metro District by office order dated 31/2012. In respect to the petitioner, that is Srimati Manju Deka, the Secondary Education Department, the Director of Secondary Education Department, the Secondary Education, had observed that the petitioner was originally appointed as the Assistant Teacher Intermediate in the Rajgarh High School in the scale of pay of rupees 1185-2395 by an order dated 30/1/1996. Later on, Srimati Manju Deka was allowed to draw graduate scale of pay with immediate effect as per the government notification dated 30/12/1993 by the Inspector of Schools, KDC Guwahati, by order dated 16/9/1998. It was observed that the government notification dated 30/12/1993 allowed graduate scale of pay to some existing teachers serving in intermediate scale of pay in different provincialized secondary schools till issue of the said notification, for which a list was annexed with the notification. However, as the petitioner Srimati Manju Deka was appointed as assistant teacher, intermediate scale of pay, in the year 1996 by the office order dated 31/1996, and later she was allowed to draw graduate scale of pay by the Inspector of Schools Guwahati on 16/9/1998, which was in violation of the government notification dated 30/12/1993. It was observed that the order allowing graduate scale of pay to the petitioner by the Inspector of Schools KDC on 16/9/1998 on the strength of the government notification dated 30/12/1993 was not found in order. Accordingly, it was mentioned that the petitioner Srimati Manju Deka, assistant teacher, is not found qualified to the post of assistant headmistress. After recording those observations, the Director of Secondary Education further observed, passed an order that as there was no break-in service in respect to the applicant Srimati Kalyani Chaudhary, the then senior Hindi teacher, now assistant headmistress of Rajkot High School. Hence, the inspector of schools KDC Metro and the headmistress of Rajkot High School is directed to make necessary correction of the service book of the petition of the applicant. It was further directed that the SSP branch of the directorate is allowed to place the matter along with all relevant records in the next meeting of the State Selection Board in compliance with this court's directions in its order dated 17/9/2021, passed in WPC number 4486/2021, and the order dated 5/3/2021, passed in writ appeal number 278/2017. It is against this order dated 26/2022 that the petitioner herein have challenged the said order. The challenge made to the instant order is only in respect to the challenge made in the petition was only in respect to the observations to the effect that the petitioner was not entitled to the graduate scale on the strength of the order of the Inspector of Schools KDC Guwahati on 16/9/1998. It has been submitted by the learned counsel, Mr. P.P. Borua, that the petitioner has no grievance as regards the correction of the service book of the respondent number 5.
I'm here. That's a lot. Can you come 2 minutes? I'll get.
Mr. Borua, let me tell you one thing. She knows this matter, you are not entitled to this, and this has been rightly passed. That matter I was telling you, M. Doctor, I've already passed similar orders to that effect, that you are not entitled to, because at that point of time, that is this particular notification was not extended to intermediate or elementary.
No, this one is already.
I've already written on top. The rest is only for the purpose of you want more clarification so that this matter survives for some time, or I can very well dismiss the petition, then everything is settled. Which one do you?
No, one thing is that this particular case.
You initially started the submission with that. You don't have a case.
The 31/2012, the order Lossi will check 31/12 is appointed as a that state administration order already been set aside with this court. This is the third transaction. That is why I'm saying that earlier occasion they have challenged this thing. The court, their appointment of state administrator, which is set aside. Thereafter, and that particular order, this notification and all this thing is clearly discusses on that single bench judgment. That's why I'm annexing it. And thereafter, they file a writ appeal. Yeah, writ appeal. The division bench did not touch the observation made by the single judge and directed to send the matter to take a decision to this state selection board, and also have a direction
So that is what they have been directed as per the division bench, that have placed materials be placed before the division bench, before the selection committee.
Before the state selection board, and state selection going to the all matter. Okay. But before they submitted to the state selection board, the director passed this order.
So
director passed this order, but giving in earlier the court said that I am the senior, I am the entire.
You can't, you are not senior.
Single bench judgment,
No, single judge judgment is not
page
there.
40.
Nothing to do.
The order start. The single bench order, earlier single bench order. It is on page 40, starting with page 40. And there, Lordship will find paragraph 40 to paragraph 5. At one stage, Lordship will find paragraph 5. At one stage, the petitioner's placement in graduate scale prior to the respondent against the available vacancy was questioned, and under communication at 5/12/98, the direction issued to adjustment of respondent in the sample where the petitioner was regularized, but the communication 5/12/98 was immediately kept in abeyance with the follow-up communication dated 27/1999. In fact, the clear direction was issued by the government or director not to give effect to the earlier order 5/12/1998. DSC was further direct to regularize the respondent in a vacant post in the Hindi teacher, and the petitioner allowed to continue as the assistant teacher as per regularization. Thereafter, the Hindi teacher of the school retired on 31/3/2020, and the respondent was regularized in the said vacancy with effect from it. The following chart will be very clearly giving the chart, the petitioner vis-a-vis the respondent. The regular selection, paragraph 8, Lordship will find the code giving the details of the petitioner and both. And paragraph 10, Lordship will find, and then paragraph 10. It can be seen from the above, the promotion is to be made on basis of school seniority, and only those with a 7 year teaching experience in graduate scale are eligible for consideration. With both contenders in the present case entered service on ad hoc basis. The respondent 5 was appointed earlier on 3/3/94 as a Hindi teacher, whereas the petitioner was appointed on 31/1996 as a teacher in the intermediate scale. However, when the graduate teacher post is become available in the school, the petitioner was upgraded to a graduate scale on 16/9/98 as per the Gov circular 30/12/93. That is logically the question. And since then, petitioner serving the graduate scale.
No, Mr. Borua, no, Mr. Borua. What has been ordered out here that you are not entitled to a graduate scale?
No. Where? The in order. That earlier the litigation.
No, that is okay. But what about this order? What is the problem with this order?
The problem is that they said I am not entitled.
Understood. So that is okay. That will be stayed for that purpose, which has been stayed by this court. I am not touching on that. You are only thing out here. You are only here. The correction, his correction has not happened because of this.
That's all like that.
Now, if they want, there is a direction from the division bench for placing the materials before the selection board. So let them be placed.
Yes.
What is the problem with that?
That's the problem.
So you are only concerned with this thing, which
that's
has
part
been
of-
only
yes.
stayed. That is what I wanted to do.
Yes.
And you are again coming out there. Yes, killer. Mr. PP Bol. That the petitioner hearing is aggrieved by the observations so made by the Director of Secondary Education in its order dated 26/2022, wherein it has been held that the petitioner is not entitled to the graduate scale of pay in terms with the order dated 16/9/1998. issued by the Inspector of Schools KDC. Guwahati. As regards the corrections so ordered by the impugned order dated 26/2022 to the effect that there is no break in service in the service book of the applicant, the petitioner has no grievance. You don't have any grievance there as regards correction? No. The Learned Counsel further submitted, drawing the attention of the order passed by the division bench dated 5/3/2021 in writ appeal number 278/2017, wherein the division bench has categorically mentioned that categorically directed the selection committee to make a fresh selection in accordance with law as directed by the coordinate bench of this court within a period of 3 months from the date a certified copy of the order is placed before the Director of Secondary Education. The petitioner has no objection for placing of the relevant materials by the SSP branch of the Directorate before the State Selection Board, as has been directed in the order dated 26/2022. It is under such circumstances, this court therefore has to take note of the order so passed on 5/8/2022, wherein this court, while issuing notice, had made it clear, had passed an order that the order dated 26/2022 issued by the Secondary Education Department shall remain stayed insofar as the writ petitioner, Srimati Monju Deka, is concerned till the next returnable date. Taking into account the submissions so made and upon perusal of the materials on record, this court clarifies the order dated 5/8/2022 to the effect that the stay so granted by this court on 5/8/2022 shall only be limited to the observations made that the petitioner would not be entitled to the graduate scale in terms with the Inspector of Schools KDC Guwahati on 16/9/1998. The order dated 5/8/2022 shall have no application in respect to the conclusions arrived at in the order dated 26/2022 by the Director of Secondary Education to that effect that there should be correction of the service book of the applicant, that's Kalyani Chaudhary, and that the SSB branch of the Director should place the matter along with the relevant records in the next meeting of the State Election Board selection. With these clarifications, therefore, the instant application stands disposed. So, very good. Now, Ahile Ikon. Heard Mr. R.M. Deka, the Learned Counsel, appearing on behalf of the petitioner. You are only challenging that thing?
Yes, my lord. Non-inaction on the part of the inspector of schools, my lord, in correcting the service book. My
Huh? Only for not correcting,
lord. Yes,
only limited.
Only that part.
Heard Mr. R.M. Dekar, the learned counsel appearing on behalf of the petitioner. Is he a party?
respondent number
Mr. Ms. D. Musari appears on behalf of the Secondary Education Department. Mr. P.P. Bolwa appears on behalf of the respondent number 6. In view of the clarifications so given by this court, by the order dated to the Azidetu, in IAC number 507/2023, the learned counsel, standing counsel for the Secondary Education Department, Ms. D. Musari, submits that the needful shall be done in terms with the order dated 26/2022, passed by the Director of Secondary Education. Within how much? Within a period of 2 weeks. Taking into account the same, the learned counsel appearing on behalf of the petitioner submits that he does not wish to press the instant writ petition. However, submits that if the same is not done, the petitioner may be given the liberty to refile. Taking into account the same, the matter stands, the writ petition stands closed with the liberty to refile if the respondent authorities do not take appropriate steps within the period of 3 weeks for doing the needful in terms with the order dated 26/2022, passed by the Director of Secondary Education. It is, however, clarified that the compliance to the order dated 26/2022 shall be subject to the order dated Azidetu in IAC 507/2000. He main contact. Yes.
Lordship, next item, my lord, is the infrastructures matter, item 23.
23 infrastructures.
Yes, Lordship.
Heard so and so. Your name?
Please, sorry.
P. Soria, the learned counsel for the petitioner. Ms. M.D. Bora appears on behalf of the
Transport Department.
Transport Department. It has been submitted at the bar that the writ petition has become infractions. Accordingly, the petition stands dismissed as closed as infraction.
My lord.
Obliged, my lord. But the item number 29, interim order is there, my lord.
Item number 29. No, I could know.
Interim order dated 27/2009. And submitting on behalf of Mr. A.N.
Why these matters come up now after 2011-2019? My goodness. Where's the interim order?
Dated 2011.
Until further orders of this court, the respondent so and so shall not release the retirement benefits. So until further orders, where's the order to release? No interim. Interim is there. Don't worry. If I extend it only, I will extend it by a few days. You will be more in difficulty.
Yes, my lord. Thank you.